Telephone's off. Good morning, everybody. It is Tuesday, July 26, 2022. This is a special meeting of the Commissioners of the City of Rehoboth Beach, live in the second floor Commissioners Room at City Hall. I'd like to call this meeting to order at 9:01 a.m. With that, we'll start off with a roll call. Commissioner Tony Sharp.
Here.
Commissioner Jay Legree.
Here.
Commissioner Ed Chernowski.
Here.
Commissioner Susan Gay.
Here.
Commissioner Patrick Gossett.
Here.
Commissioner Tim Bennett.
Here.
And Mayor Stan Mills. We have a full complement, and we are formally able to conduct business because we have a quorum today. With that, I'd like to thank everybody that's watching virtually. We don't have anybody live in person in our room right now. Hopefully some people will show up because they will be welcomed. And with that, I'd like to remind everybody that support documents when they are available, that is, documents that support our agenda items when they are available, are embedded into the agenda, available on the online portal within the City of Rehoboth Beach website. The purpose of this special meeting is to review proposed revisions to existing Chapter 253 trees, which, as if you've been following along, has been reformatted into 4 articles noted on the agenda. We have been working on this now, I believe, over 10 years, and hoping to bring it to a conclusion. However, I would like, rather than take this in sequence tonight of Article 1, 2, 3, 4, we're going to pause and look at a new sequence tonight and introduce a zoning discussion into this, and for which the outcome of this discussion will determine our path forward, whether we pause a little bit, go a new direction, or continue that direction. Susan, do you want to take it over or introduce this, or go right to Glenn?
Well, I was just going to say that instead of starting, as you just said, with the articles, we should talk about the issue that Glenn has raised first, and at least make some, even if we don't settle it, the zoning issue right now, at least have a path forward, and then we can go from there. And I do have some process notes about how we would move forward after that discussion.
Thank you, Commissioner. So let me apologize at the beginning for bringing this new topic to you, because it is sort of a different lane than what you've been in. But as I got into the legal review, I ended up looking at a lot of other ordinances and ways that it's done in discussions on the internet, and there's definitely a move toward putting tree regulations within the zoning code, or at least treating them as a zoning ordinance. Remember that the zoning ordinance is really the regulation of private property, and it's all about providing for the general health, welfare, and safety of the community. So the regulations you implement through zoning is supposed to kind of be focused on those objectives. Everything, and as I thought about it, everything we're doing with tree canopy, the reason we try to have a tree canopy in the city is because it's about the health, safety, and general welfare of the community. So it seems to me when you're regulating private property, and whether it's trees or structures or whatever, when it comes to this sort of regulation, it seems appropriate to put it in the zoning code. And as I looked at other codes, certainly there are codes where it's a standalone chapter, like we currently have it in our code. But it seems to me the trend is that as these tree regulations become more and more sophisticated, they're moving toward the zoning code. There's discussions about whether tree regulations can effectuate a taking and all these sorts of things. So I just wanted to raise this with you to see if there is an appetite for considering whether it should be in the zoning code or not. Obviously, if it's in the zoning code, there's another layer of hurdles that you all have to go through if you're going to amend the tree ordinance, because now you're in the world where you have to give 15 days public notice. You have to go to a public hearing for any amendments, where it is currently, we don't have to go through those rigors. However, I think that in the new version of the tree ordinance,
we're going to do that anyway.
Right.
Yeah, we were going to have a public hearing anyway. That's
right. So it's somewhat treated as a zoning reg, even if it's outside. And I don't know that I don't believe that it has to be within the actual chapter called zoning. But I think that if you come to the conclusion that this is the regulation of private property, that whether it's in its own chapter called trees or it's in the zoning chapter, it should be treated, it should be given all of the treatment that a typical zoning ordinance gets. I think ultimately, if you decide that it should be treated as a zoning regulation, it makes the most sense to find a way to integrate it into the zoning code itself.
Well, obviously, this is a significant new introduction of
Right.
maybe a change in path. You know, there's a lot to think of here that that if we don't have to make a decision today necessarily, but we certainly, I think, have to commit to looking into it if we're going to pause. Because there's many questions on my mind about it. That right now the appeal process is that appeals are taken to the Parks and Shade Tree Commission. If we put this in the Zoning Commission, would they go to the Board of Adjustment? Because the Board of Adjustment is, I think their official name is Zoning Board of Adjustment, but they deal with zoning issues. So they would be the one to hear appeals. And yet, if you look through the code, there are still duties or responsibilities of the Parks and Shade Tree Commission doing different studies and looking at annual reports. I'm not sure that we can get rid of them in entirety.
No, we might not want to.
And they need to be they need to be received. I would be probably more receptive putting it in the zoning code if we had had the ability to have a separate Parks and Shade Tree Commission Board of Adjustment, you know, just for the tree things, because right now we've got a great group of people that are the experts in the trees. And the Board of Adjustment would take on extra burden, obviously, but they would also have to re-educate themselves. So there's a lot of questions, I think, come up. And again, what we want to do is have a discussion today, see if you want to go that direction. If we do, it causes us to do a few things different. And we can still review Articles 1, 2, 3, and 4, right, Susan? However, there are anything that has to do with the Parks and Shade Tree Commission that would carry over to a Board of Adjustment, we would not discuss. We would purposely suspend discussion on that. And then we would have to turn it over to Glenn to start a review of how to change it and what happens. Susan, do you?
Yeah, I mean, I actually think that, and when we talk about process after this more, concept discussion, I was going to get into that, but I think it's probably moot if we move in that direction to talk about Articles 1, 2, and 4 today, because if they're only minor things that have come up anyway with that, and they may be moot if it gets moved to another part of the code. So I would rather concentrate on Article 3, which is the regulations on private property, because we still have a couple of unresolved issues there, and if we resolve them, then we can easily move ahead. And one of the things that I think is important to note here is that we're talking about placement within the code. The regulations are going to be the same no matter where it is in the code. So I don't think today talking about Article 3 is a waste of time at all, because the regulations are going to exist. It's just a matter of where.
So listening to Commissioner Gay, I have a couple of questions for, I think, maybe the solicitor, city solicitor, or Commissioner Gay, or anybody. I'm kind of curious, when you talk about a movement, when you're doing research toward putting it in the zoning code, could you discern how long communities have been moving in that direction? Is this brand new? Has it been there for 5 years, 10 years? What does it feel like?
I think there's probably tree ordinances that have been in zoning codes for more than a decade. So it's certainly not brand new, but it seems to be a lot more people are catching on, and that is perhaps because there's more discussions about, well, I think there's been cases and judges have sort of made decisions that have caused communities to go, oh, wait a minute, maybe we should treat this like a zoning regulation.
So this is not new news
Not
to
new.
us, really?
It's not.
Okay. So what are the benefits? I'm trying to answer the question for me, why now? Mm-hmm. Why now? So I'm trying to figure out, so I can process, what are the benefits to the city, And then conversely, what are the benefits to the property owners of having it in the code, the zoning code?
Let me just interject the why now thing. Glenn brought this, Susan's been working on it, and I've been working with her and Glenn on this for a while. I give a little feedback, and they came to me with this proposal. And I said, we've got to bring it forward. I mean, it may throw a wrench into the works, but it may not. It may be the thing to do. But now, in my mind, was the time to do this because we're doing such a significant major overhaul of the tree code. What better time to do it than now? So if we go that direction, admittedly, it's going to postpone this a little more, but after 10 years, what's another half a year? Oh, goodness, I don't even like to laugh or joke about that. I'm so anxious to get this done. But anyhow, that was my thinking, that we needed to bring this forward and everything. Did you want to?
Yeah, thanks, Mayor. I guess I would say that, sort of the benefit to the city is that, when I kind of weighed it, there's some additional legal protections that come into play because we're going through all of the rigors that a zoning ordinance requires. As Commissioner Gay says, that's already kind of built into the new tree code, so it doesn't give me much concern as it would if we stayed with the ordinance as it currently is, because now the new version provides for a public hearing and provides for public notice. So the benefit to the city, I guess, is one more layer of legal protection because you would be treating it as a zoning ordinance and going through all those public notice provisions. The other benefit, perhaps to the city, is that, if it's in the zoning code, there's a better integration, I think, of maybe what Liz is doing in her part of the house and what Matt's doing in his part of the house. And I mean, they're across the hall, they talk a lot anyways, and it kind of gets worked out. But now you're looking in one chapter for everything that is private property regulation. The benefit to the homeowner or the private property owner is that, if this Board of Commissioners is going to be passing laws that can affect them, and monetarily the numbers can get big. They should have notice and be able to come to a hearing every time that a change is being made to that law. So I guess that's the benefit to the private property owner. Beyond that, I mean, the difficulty. So I think that generally the changes that we've got in the new code treat the ordinance as a zoning ordinance, but for the Board of Adjustment piece, that's something that I think you really have to work through and think through. If it goes in the zoning code, I don't think there's, I did look at this a little bit, and I don't think that there is an allowance for an alternative Board of Adjustment that deals with trees. I think the state code has set up a Board of Adjustment, can't be more than 5 members. They're the ones that vary the zoning regulations, and I haven't seen an example where there's a second Board of Adjustment to deal with a defined category of issues. So I think that's one issue to be dealt with, and perhaps through attrition and appointing new members, you end up getting some of the tree-oriented people on the Board of Adjustment.
So you don't see a path for a subgroup?
I don't. The only thing I saw was some Boards of Adjustment have alternative members, but I think they're only alternates if one of the primary members says, I just can't make it, they come in. I haven't seen where these 3 sit it out when it's a tree issue and the 3 alternates come on the board. So I think it would be our Board of Adjustment would hear appeals of tree issues.
Because if I'm understanding this correctly, the substance of the context and the substance of what we're reviewing will not change depending on if it's in the code or if it's in the zoning code or not.
That's the intention, as I understand it, right?
There are some things, yeah, and I do want to talk about that. There are some things that would be a little different, but I want to talk about the sort of concept of it first, and I'll get to that.
And I don't think everything would go into the zoning code. So
Right, that's why it would change.
Right. So
Yeah.
that's what probably triggered my thinking that anything dealing with street trees or city trees or park trees, that wouldn't go into the zoning code because, again, the zoning code is intended to regulate private property, not public spaces.
What currently is the appeal process? It goes before the park, that committee.
So
And sorry, if they get a negative outcome, what's the appeal process?
They appeal to the commissioners, the Board of Commissioners.
So that is the one thing I like not having it in the zoning code is that they can appeal to us rather than the court.
Right.
Yeah, just make that clear to everybody that, just reiterate that.
Right, so the current process is somebody goes into building and licensing, asks for a tree removal permit. If Liz denies, if the city arborist denies the tree removal permit, there's a right of appeal to the city's Parks and Shade Tree Commission. The applicant comes in or the appellant comes in, states their case to the Parks and Shade Tree Commission. If the Parks and Shade Tree Commission deny the appeal, then that individual can further appeal to the Board of Commissioners. So they'll come before you and say, I didn't like the answer I got at Building and Licensing, I didn't like the answer I got at Parks and Shade Tree Commission, will you hear my case? In a Board of Adjustment context, an individual has a right, so if somebody comes into the Building and Licensing and asks for a permit and the permit is rejected or other zoning issues, the appeal process is to the Board of Adjustment. The Board of Adjustment will hear the case, and if they deny the appeal, there's a statutory right of appeal to the state superior court. And because it's a statutory right of appeal, the Board of Commissioners here couldn't even insert another step that says you can come to us before you go to Superior Court, because it's a statutory right of appeal.
So that's
So,
very
Two
important
different processes, that's right.
distinction there.
And that's the same process for any zoning denial.
Right, that's right. Right, it doesn't have to be a permit, it could be, yeah. Mhm.
Could you talk a little more about the legal protection that you think putting it in the zone, like if somebody didn't like the answer they got from Parks and Shade Tree, not so much the appeal process, but if they just didn't like the fee they were charged or they didn't like what they were being required to do, how is it better in the zoning, how is it more protective to the city in the zoning code?
Well, again, I think that you've probably cured most of the issues I'd be concerned about with this rewrite. The whole idea when you regulate a constitutionally protected right, and property right is a constitutionally protected right, is that individuals are entitled to due process. Due process means notice and an opportunity to be heard. So you need to give people, so if you're gonna change the rights that people have with regard to their private property, you have to give them some form of notice, and they have to have an opportunity to come in and be heard, and that's accomplishing the due process requirement. In the zoning, if we were to place it in the zoning code, those protections are built in because you have to give notice and you have to give them an opportunity to come and have their case be heard. Again, that's cured in the new version, so I don't have as much concern about it.
It's not cured in the sense that we're not required to have the hearing, we just are doing it. In other words, there's nothing in the code that requires us to do the hearing, and there's nothing in the code that requires us to do a hearing if there's a change in it down the road. We just happen to be doing it this time.
I see, right. Right,
And so
I
that's
see.
why I wondered if on a
got you.
case-by-case basis, there's more legal protections to the city in the zoning
Yes.
code. Didn't you say that?
I think that's right because, it's a built-in protection in that everybody's mind knows that if it's a zoning change, you have to go through this process of giving people notice and having a hearing.
Glenn, knowing what we want to do, did you have a professional opinion one way or the other?
Yeah, I would prefer to see it in the zoning code, if not in the zoning code, at least treated as a zoning ordinance with all the protections that come along.
And I don't have a problem with that, but I agree with the mayor. I think taking the Park and Shade Tree out of it is a mistake, and I don't know if we can, is there any way we can make our own rules on that?
Well, again, my statement had to do with not the appeal process. I mean, I wish the Parks and Shade Tree Commission could still be the one to hear appeals. If we put it in the zoning code, as Glenn has indicated, likely not. It's going to have to go in front of the Board of Adjustment. But I want it clear also that as we read through the code, there are studies and annual reviews and things that are tasked to the Parks and Shade Tree Commission. So we would still have to keep them in there, but it's the appeal process that's soured me a little bit, that I wish we could keep them.
So I have a couple thoughts on that, I guess. I mean,
I'm sorry to interrupt. Go, did,
No, I'm
you're
done,
good.
thank you.
I just had a question about that appeals process. And I don't know whether, Liz, if you could, any idea of just an average number of appeals annually that go to Parks and Shade Tree, or Glenn? I mean, you both sit in there.
Well, it depends on what we're calling an appeal necessarily, because we get a lot of those street tree cases that are cases, but not appeals. And then we get a lot of fee in lieu of mitigation, which they're technically appeals, but they're not really appeal of an issuance of a, or a denial of a permit.
So
So if we're talking about straight, like appeals because I denied a permit, maybe 5, max 10.
All right.
It's not many.
And so if we were to move forward in placing this as part of the zoning code, then would there be a clear definition, if you will, or a clear path as to what would be, if we maintain the Parks and Shade Tree Committee, what would go to Board of Adjustments and what would go to Parks and Shade, so that the applicant would know if they're denied, which direction do we go here?
I think so. I'm sorry.
I think that would have to be clear in the code. You make an interesting point there, Liz, in that street trees don't go through a normal appeal process. So I think we would.
Appealed at all.
They
It's
can't.
taken out.
Okay. Well, then that would resolve it.
That would
Okay,
resolve
because
that, yeah.
I was going to say, otherwise, we're going to have to put something in the code
Right, yeah.
that says the Board of Adjustment has authority over that, and now you're saying that we. with the-
Well, I mean, I guess one thing to keep in mind too is, as I said earlier, I don't think anything that deals with street trees or park trees would end up in the zoning code. So I think that
Right,
most things that would come up under the zoning code would go to the board, all things that come up under the zoning code would go to the Board of Adjustment. We'd have street trees and park trees in a different chapter, perhaps, in streets and sidewalks, Commissioner Gay was
That
suggesting.
could still go
That would-
for a decision before the Parks and Shade Tree Commission,
If you wanted to give that, right, if you wanted to give.
if we were to go that direction.
The other thing to think about, I guess, is because there seems to be some appetite to keep the Parks and Shade Tree Commission involved if there is an appeal process on private property issues. You could probably write into the zoning code or another area that deals with the Parks and Shade Tree Commission, the idea that when an appeal comes before the Board of Adjustment, that not only does the Parks and Shade Tree Commission have the opportunity to weigh in, which they would have anyways, they could weigh in, you could require that they provide a report to the Board of Adjustment, their kind of analysis of the situation and, what are the benefits and risks of granting the variance.
You just answered my question, because I was pondering, could we create a different process that enables Parks and Shade to give opinions or consensus or something around an issue?
Good.
So you would have to rewrite or establish roles and responsibilities for the, if you will, newly defined Parks and Shade Tree Commission, or whatever we're going to call it, that type of thing. But Board of Adjustment comes out of Title 22, state code. Does the Parks and Shade originate in state, local, where do they develop?
That's why you have a lot more discretion over what you can require them to do or not do, is because they are a creature of the city of Rehoboth Beach. You created them, and you can breathe whatever life into them that you want to.
If we decide to go forward, I think obviously, I think we should task Glenn with doing further analysis on the pros and cons. But also, if we decide to go forward with this, I think we still need to review in entirety Articles 1, 2, 3, and 4. And at that time of review, I think it would become more clear on what the changes need to be, what would go to the zoning code, what would stay outside of the zoning code, and how the responsibilities of the Parks and Shade Tree Commission would change.
Could we also have some offline discussions or solicitor to have an opinion or just discussion with the Board of Adjustments and also Parks and Shade Tree Committee to see if they have any opinion of how this process would just be impactful to them, or just get some perspective from there, because since they're the ones that actually process this,
Yeah, I'll reach out to them. I was contemplating doing that beforehand, but this is the introductory discussion, number one. Number two, part of me also says, well, while I would value their opinion, if we're sending it to them, we're sending it to them, and what if they come back and they say, no, we want nothing to do with it, but the majority up here says, well, we do want it. So I have mixed feeling, but I will be glad to reach out to
Well, I just-
different
again,
agencies.
that
Yeah.
Sometimes you learn about things by reading it in the paper as opposed to, so just as a courtesy
But we still would value their opinions, and so I'll reach out to the different agencies.
Mayor, let me back up a step and make a couple of introductory, because I've had, I've found out about this on Thursday. So I've had just a few days, but a few days to really concentrate on it. And of course, I cannot repeat what my first reaction was when I heard about it on Thursday, given all that's been put into this and all of the discussions and all the hours that you all have spent on it. But one of the things I did was I wondered, well, how does this fit into the CDP? Can we even do this? I do think it's logical because zoning is about land use and trees are part of land use. But I thought it was interesting. I actually went back with kind of a different eye to some of the sections of the CDP. And in addition to our long history of preserving trees and noting that Rehoboth is unique among beach resorts on the East Coast because of the abundance of trees, the current CDP talks about the decline of trees due to construction, storms, and natural causes. And that, quote, given new national concerns over global warming, a new and bolder strategy is needed, including public policy change and adopting high standards of maintenance and replacement. So I started thinking, well, that not only, so the CDP would give us permission to do this, because it adds a key environmental element to the purpose of the zoning code. The zoning code starts out with a purpose that is great. It's general, talks about public health, safety, and welfare. But nowadays, these environmental issues really rise to that, to the level that they need to be, called out separately because, the code talks about land use, it talks about buildings, but really the environmental component. So I do see it as kind of elevating the tree code a bit, given these concerns. But also, I think it's a first step. I think it could be a first step at looking at the entire zoning code, which we've talked about for several years now, and that's also in the CDP, to look at the code, to look at ambiguities, to look at making processes clearer. All that's there, and I think speaks to the process we're going through now. We, I believe, have an agreement that whatever zoning code changes are made also get a code review by a planner, so then the tree ordinance would be subject to that, which I frankly have wanted since the beginning. And I think, as the city solicitor mentioned earlier, it does assure that the rest of the zoning code kind of dovetails with the tree code, because now we'll be looking at it all together. So I think there's some advantages to doing it. There are obviously and I think there's potentially a downside to not doing it, and that is that there would be if we don't do it, if we move ahead with the way we have it now, then there may be a delay in reviewing other key code provisions. And there's also the risk that in 6 months, you all may decide, well, it really should have been in zoning after all, and then there's a lot of wasted time. So there's already going to be some work that is going to be put aside or double effort to get this right. But I think it's a process that if we're going to do it, we ought to do it, sooner than later. And in terms of, so with that in mind, because given the fact that it looked from what the solicitor was saying, this was his recommendation of where to go, there are some things that will need to be done that I'm not sure can be done, here in this meeting today. I was hoping that we could focus on Article 3, the private property regulations, today for 2 reasons. One is that there are a couple of issues in that, such as the mitigation and the tree protection, that are still sort of unresolved. And we need to finish that up. And as I said earlier, the regulations are the same no matter where they go in the code, so we're not wasting any effort by doing that. But the other articles are going to change. Like, for instance, Article 1. the definitions would be merged in with Chapters 270 definitions, and in fact, there are already some overlaps. The lot appears on both, natural area appears on both, and demolition only appears in the tree code, but not in the zoning code, and that actually came up in discussion recently about the sandcastle. So there's a benefit to that merging, but that merging would take place, I think, before we discuss Article 1 again. And then the whole issue, and I want Glenn to talk about this, is the trees in public space, Article 2, better known as the street tree ordinance, but we did broaden it. We did broaden it to include a requirement for an urban forest plan, and I think we have a definition in there for city trees and park trees. And my understanding is that the city can't be, you can explain this better than I can, that the code does not obligate the city to do anything. It can't. That's not the job of the code. So anything, the street tree part of it with what citizens could do related to street trees would still be in there, but anything that the city agrees to do is more of a policy and not a code, right? Is that what you're talking about?
That's always my preference. If there, the code generally is for regulating not the government, but the people who are subject to the government. So generally, codified provisions are aimed at that objective. So if the city is going to do, think about our document retention policy, for example. That's a policy you set up, so internally you would have a policy to deal with documents. If you codify it and say the city will retain documents for 3 years and they'll be this way and that way and that way and that way, that way, somebody's going to say you didn't do it right and sue you like that. So I'm always concerned about if it doesn't have to be a code item that regulates the government, maybe it doesn't need to be in the code. The reason that, if, however, you want to provide for urban forestry within the code, which I don't think is a horrible idea, but I wouldn't like to see that in the zoning code, because what happens is if you want to change the way the provisions that govern your urban forestry, if it's in a section outside of the zoning code, and it doesn't need to be in the zoning code because it's your regulation, you can do that without a public hearing and without any kind of notice. I know that we like to give notice and hold public hearings, but you don't have to. But if you put it in the zoning code, what I worry about is then your hands become tied a little bit because you're required to have a public hearing, and you're not just required to conduct a public hearing, but you're required to hear what's said, and you have to you have to make a rational decision. And if nothing comes in on the record during the public hearing that supports your decision, then again, you're exposed to litigation. Whereas if it's truly not subject to a public hearing, you can really have your own debate up here and make the decision you want to make and not have to go through that due process requirement. Again, I know you like to do public hearings and stuff, but my job is to not require you to have a public hearing when you're not actually required to
No,
have one.
I'm going back to the comments you made about the city not being able, that tasks that obligate the city to do something shouldn't be in the code because of the legal exposure, you said that?
It creates exposure.
Okay, because then I have a question, because this has come up numerous times, not just with trees, but with other things, where the citizens want the city to lead by example. If we take these requirements out of the code, how do we prove to the public that we are leading by example?
Well, I guess to me, it comes down to do actions speak louder than words? Because words in the code are great, but how does the city actually conduct its business? And whether it's in a policy or whether it's in a code, I'm not sure that it makes a whole lot of difference to people. Maybe it does, but a policy document, I always think, does not create as much exposure, legal exposure for the municipality as it does, as is created if it's codified. So I think that leading by example is more powerful, I guess, than what words are written in the code.
And examples like the urban forest plan are in the CDP.
Right.
They're a requirement now in the CDP. So I guess that has
True.
those things obligate us from a policy perspective, right?
Obligate?
Well, I agree with Glenn that code is not intended to dictate city actions. I would pull all them out in the policy.
Right.
I mean, look what we do for LED lights, we have a policy that indicates when LED lights or street lighting changes that dark sky like light fixtures are to be considered and stuff like that. So I fully believe that the city does and should look at these policy items as dictates whenever they can.
Yeah. Well, and so that's why I don't really want to talk about Article 2 today either, because some of that stuff would come out. And Article 4, obviously, the appeals process, Glenn still has a lot of work to do on that one. So that was why I was wanted to focus on completing the private property regulations, and then after, the next steps would be working with Glenn on the other elements and getting the planner review, and then bringing back the final code, and then for you all to take to public hearing,
If we want to go that path.
if you want to go
today.
that path.
That was
That
were
was
you
my
gonna
process.
I was just trying to figure out where is it that we want to go with this zoning issue? And how do we really want to land that plane in the next short period of time? So I just wanted to offer for me, it seems to make perfect sense to me, especially based on parts of this discussion, because when you talk about the city leading the way, the whole thing boils down to me is, are we serious about our tree code? Are we serious about preservation, or are we not? So it makes sense to me that if we had a situation that not only supports what's in the CDP, but to me, it should support the environmental group needs as well, that we're starting to tie together the things that are important to move us forward, that makes, I would think it makes it easier when you go into, let's just say for a new build, and you're doing all of this in association as opposed to what sometimes feels more piecemeal. So for me, if what we're trying to do is just advance, should this or should this not be in the zoning code? To me, it feels like a right thing to do as far as exploration. And I'm just not sure, what is that next exploration? You may have already mentioned it and I lost it already, but what is the next exploration step?
Or putting it in the zoning code?
Well, I thought I heard that's how we would advance this.
Yes, I mean, I
So
like
what
to say,
is that step again?
I think that the goal would be to try to finish what is currently Article 3, the private property regulations today. And then separately, Glenn would be working on the appeals, and he and I would be working on taking the other provisions, the Article 2, the definition, merging that in, and then coming back with a document to be ready to discuss that would ultimately go to public hearing.
And then I would be reaching out to the agencies to get their input also. I mean, I find this attractive, especially in light of tree codes trend throughout the nation trending toward being included in zoning chapters. And also, I find it would perhaps it'd be more legally defensible to do that, according to what I'm interpreting Glenn saying. So I think we have a path forward. If there's a consensus to do that, I'd like to see nods of heads or oral comment on that. And then we know the path forward. But then for the remainder of the day, let Susan lead the conversation on Article 3, which we haven't yet to discuss. Have we discussed?
We have several times, but there are a couple of open issues.
Okay,
And in fact, I may focus on those.
So we would
rather
need to
than
go
talk
with
about-
that. If we could keep advancing this
Yep.
toward to the point, my goal would be to someday get to the point for all these articles that it's just in black and white, no red line version, so that we can share it with other arborists and the public, and they can see here is the proposal. And I think we're getting there. It's just a slow process, but I think we're being very methodical, and that's appreciated. Is there any further comment on the direction we're going with this?
I'll weigh in on the zoning piece. I'm not in favor of moving that forward. We're taking away an administrative appeals process from our constituents, and just the fees alone, it's $1,000 to go before the Board of Adjustments. It's currently $250 to go before the Parks and Shade Commission. And the fact that we're taking an appeals process away and forcing them to go to court, I just don't think is a good move for our constituents.
Okay, okay.
I agree with Commissioner Jernowski. I totally agree. Looking at it from a citizen's viewpoint, I hate to see the ability to appeal to the Board of Commissioners over a tree situation and have to think about hiring lawyers and going to a higher court. Just, I don't think that's, if we could figure out some way to, if we could figure out some way to keep that, but if you make them subservient, if you make the Shade Tree Commission subservient to the Board of Adjustment, you're just layering legal steps in there that are costly. And
Right.
one of the things that I hear from citizens is it costs so much to follow the code, the Shade Tree Code.
Well, I don't disagree,
Yeah.
but I'm willing to direct all of us to see what that next step is and how would it actually look going to the zoning code. And that's a little effort. Doesn't mean that necessarily I'm willing to commit 100% till I know what the details are. But Glenn, is there, I think state law dictates the appeal process for and how the Board of Adjustment conducts their business. Can we codify anything that says failed appeals in front of the Board of Adjustment that deal with tree issues can come back to the commissioners? Or is that all part of state law? I think.
I don't think so. I mean, I said earlier that I don't think that you can insert an additional step in there. That's worth, that's worth doing a little bit of research. Perhaps so long as it's not a required step. You know, so a person has a statutory right of appeal from the Board of Adjustment to Superior Court. Sometimes, you know, we say that you can't go to state court until you exhaust your administrative remedies. You have to do everything at the municipal level that you can do before you can go to state court. So generally, that's the way it's thought about. But perhaps here you could create an optional appeal. You could say you have your statutory right of appeal to Superior Court. You do not have to exhaust the administrative remedy of coming to the Board of Commissioners. So if somebody wants to go straight to, so if somebody wants to go straight to Superior Court, they have that statutory right and they can do it. But perhaps you could write in an optional appeal to the Board of Commissioners if you wanted to, and that's something I'm going to have to look at and be sure that it's.
Yeah.
Would that be more appetizing to you both, for instance?
I would consider it at that point. And also if we could change the fee structure, if it was going to the Board of Adjustment, change the fee structure for these types of appeals.
I think we were going to try, there is a note to look at the fee structure for going to Parks and Shade Tree as not being enough. You know, so, I mean, I'm not sure that it was, that the 250,000 comparison is going to be there anyway.
Right.
You know,
Why is it not enough?
staff time. I think there was a note made about having to look at that to see.
Yeah, if we're actually losing money,
Yeah.
honestly.
Well, there's a comment in here
Comment
that when we
to
get
that
to it,
effect, yeah.
we can
Would we
address that.
reduce staff then if we go forward with the, of taking that appeal process out of the, or raising the
No, that's
cost?
still appeal, it's just a different.
You said staff time
Well, they would still,
counts,
my assumption is that
correlates
they
to
would,
money?
my assumption is they would still appeal. For instance, if the appeal went to the Board of Adjustment, would our city arborist still have a part to play in going in front of the Board of Adjustment?
Well, somebody would have to, right? Whether it was
yeah.
me, I mean,
You have to give the city's point of view.
well, think about it. When was the $250 fee set? 15 years ago?
More.
Yeah, so, I mean, we have
That's why.
legal, we have city secretary's assistant, me, then it's usually run, we usually consult with the building inspector, then we have all the administrative time in order to actually process the payment, which comes up to building and licensing, I believe. So there's quite a bit involved, and I would hazard a guess to say quite a bit more involved now versus 10 years ago.
Now, that's one of the things that the code review process is apparently shown, is asking, you know, that because we had asked for what the code review process was showing for trees, and the answer we got back was they were asking about all fees.
Well,
All
and
fees current.
I don't want what Liz just reminded me of, because she said it many times before, that we're actually losing money. We're losing
Probably.
money. And in my opinion, if we're losing money as a community for something that is entitled to resolve a situation, we have to look at that. We can't just say, well, we'll leave the fee where it is and we'll lose money and that's okay. That doesn't make sense to me.
But hopefully, this 10-year process of updating the code is going to reduce the number of appeals.
Well, yes.
I mean, that
is the
ultimately
goal.
is the goal
Yeah, absolutely,
of what
that
we're
is the
doing
goal.
here.
Yeah.
But I think equating losing money with making the citizen pay is, in my mind, a faulty correlation, because we're paying the salaries of all the staff people as it is. And to ask the person who's making the appeal to pay is, I think we're raising the fees just to discourage appeals. Are we doing that? Do I have an answer? Or is it, am I wrong? Is it strictly to pay for the staff time? I can't make that correlation.
Would it be just overhead cost, I think is what it would fall into as well. I would interpret it. And Liz, remind me again, how many cases would you say would go, if we went to the Board of Adjustment process in past history, how many would go maybe? Average?
I mean, I think you could say as few as 4 or 5, maybe as many as a dozen, just give or take the year. And I would think that the revised code would result in less overall. I don't think the fee is necessarily a deterrent either way, whether it's $250 or $400. I don't think that's a deterrent for people. Because think about how much a new tree costs to plant.
Right.
And
Nor should it really be. I mean, but in the same sense, like we have permit application fees and stuff like that to show that you're serious about getting the work done. That's why we require an estimate. You can't just walk in and say, I want to remove these 3 trees. You have to have a little bit of work put into it.
The Board of Adjustment fee's been $1,000 for a long time, hasn't it?
yeah.
So why is it so much more?
Do they have a lot more staff time? Do we pay those people a high salary?
Well,
Try no.
Each case, I think, is more complicated with Board of Adjustment. I mean, we'll have park and shade tree cases that are like the fee in lieu of mitigation ones are usually pretty simple and timely. The actual appeals that we're talking about, the 5 to 10, those take quite a bit of time.
That leads to my point. Whenever the Board of Adjustment gets involved, it seems to be a long process. And so I'm wondering, versus the way it is now, if we bump this to the Board of Adjustment, and I'm a resident, and I appeal, or I don't like what I heard from Park and Shade, how long will it take to get resolved if it gets into court?
Into court?
Well, because
it goes-
that's what you're saying, right? Rather than them coming to us and us making a decision, I think we had one a few months ago where it was 3-4. We made a decision about a tree. But in the process now, it would go to the Board of Adjustment, and then if they still wanted to appeal further, then it goes to litigation, correct?
Well,
It bypasses us.
Let's look at it at the beginning and then go to court. To be able to just be heard by the Board of Adjustment takes a minimum of, say, how much? 30 days. If they catch it and at the right time to get published before that meeting, a minimum of 30 days. So I'd say likely 30 to 60 days. So 2 months to get resolved. That is if they hear it and resolve it at that, and come to conclusion at that meeting. Otherwise, it can be deferred. I mean, we've got one case now that's 6 months into it, you know?
Is that-
For different reasons. But then beyond that, if the variance is not granted and then they appeal to the courts, that Lingo case took 6 months or what?
Easily 6 months, probably closer to a year in most
And-
cases.
Is that timeframe similar when you appeal to Parks and Shade Tree? Is it a 30-day, or 60 days? So there's really the only difference is the appeal of whether it goes to us. And Glenn, you've been here 16 years. How many appeals has the board heard in 16 years on trees?
Yeah, I can only recall 3.
3?
But they would we would hear them likely, wouldn't we, within 30 days or so after?
It was, the
I mean,
one I knew was
the
60.
earliest would be 30 days. So I guess the point is, if it came to us, we would hear them in a much expedited time frame than if it went to court.
Right. You would hear them.
And the
and make a
cost would
decision
be
for sure.
significantly changed too, right?
That's true.
So 30, 60 days versus 3, 6 months.
Yeah, I mean, I guess the only other thing to think
Or
about is that,
appeal, second
Right,
appeal.
right.
right, if the Board of Commissioners doesn't grant the appeal, I mean, there's still a litigation option and you'd still be in that year-long process. So,
Okay.
Has that happened quite a bit?
no, there's only been, since I've been with the city, there's only been 3 tree appeals that have come to the Board of Commissioners on appeal. And I don't remember any of them taking the next step to litigation.
So that's 0.
Right.
The answer is 0.
But it's
I'm
still,
struggling.
I understand it's not a lot of cases that have done it, but the perception is we're still taking an opportunity away from our residents.
I thought it was interesting when Glenn first brought this up, the language in the tree code now for what parks and shade tree and how they make their decisions seems to be taken right out of the state code for the responsibilities of boards of adjustment. It seems to have been purposely written to mirror that process anyway. And I think what you said is that shouldn't be the case, right? I mean, that there's a disconnect there between what they should legally do and the process that's set up.
Sort of, I mean, I guess it was one more piece of it that started ringing the bell for me that that the commissioner should really consider whether this should be part of the zoning code or not, because if looks like a duck, quacks like a duck.
Yeah,
you know,
that's how it came up, I think, when you were reviewing it, yeah. Right.
Glenn, just one last question. Does our insurance carrier care at all if we change an administrative appeals process?
I think probably the analysis that the carrier would do is what, by changing this code, what kind of exposure do we have? So part of it would be, all right, if we don't have this administrative appeal process to the commissioners, then maybe there is an incrementally higher litigation exposure that people will go to state court versus trying to have it handled here. The other side of that analysis, though, I presume would be, well, if the code is currently written isn't legally sustainable because it's not treated as a zoning ordinance,
Right.
that also creates exposure. So
Right,
I mean, they're going to do analysis that says, well, maybe there's less exposure if it is part of the zoning code, regardless of the appeal procedure.
So we've got Commissioner Legree, Commissioner Chernowski that tend to favor continuing with the process we've got.
I think I'm in that camp right now, too.
I'm sorry, what?
I think I'm in that camp as well.
And I'm at a 0.5 because I'm willing to agree, but I'm also willing to let it go forward so that we can better understand all the ramifications of going over to the zoning code or not. Does anybody else want to offer anything?
Well, the only thing I would add to that,
Yeah.
Mayor, is that you've given me some homework now to figure out whether there is a possibility of an optional appellate process at the Board of Commissioners, so a person wouldn't have to go to state court, they'd have the option of coming here, and that might inform your decision a little bit too. So I'll look into that.
And I'm not going to go on the record one way or the other, although this idea seems not only got when Commissioner Bennett asked what your recommendation is, City Solicitor, you're seeing more pros to this than cons. But I want Glenn to do his homework and get back to us and let us continue to mull this over.
So
I do too. I'm sorry.
I think that's the route we'll go then, if you don't mind. I understand your positions and you can certainly articulate those again, but we've kind of set a path forward with Glenn doing further analysis, me seeking input from the different agencies, and Susan, you were going to work with Glenn on the appeal process and everything. So with that.
You cut me off.
Oh, I'm sorry. Go ahead.
I want to hear more about the one more layer of legal protection, Glenn. Thanks, Mayor.
Oh, that's additional homework for Glenn. right?
Yeah.
Right, okay, okay. You got that?
Glenn, could
Very
you
good.
also determine, are there any other cities or municipalities in Delaware that offer tree protection or their tree code through zoning? If you could let us know on that also.
I will look at that.
Thanks.
Well, we've got the city of Lewis, I think, is currently looking into a tree code, and I know that, I understand they're looking at us, so they may,
Well,
yeah,
that's true. I mean, we're kind of the leader, and so like, we probably should get this right, this piece of it, so.
Yeah. Are they far enough along in their discussions? I meant to ask you this too. Are they talking about zoning? They're not talking about where to put it.
No,
They're just talking.
they're very, very infancy. I mean, I think they've met once, maybe twice, so,
Okay.
so very.
They got their
early on.
work cut out for them.
So I think Liz, at some point, they're gonna invite you to come talk with them, if they haven't already, so they've mentioned it.
Oh, pause a minute. Any members of the public like to say anything? Nope, okay. None at this time. So Susan, we'll turn it over to you. I understand from our conversations, you'd like to start with Article 3, version
again,
3.
The reason for that is not because there aren't some things that, but given where we are, I just hesitate to devote any more time to things that may change. Whereas Article 3, the regulations are not gonna, they may be changed where they're placed, but they're not gonna change, so I feel like we have to get those settled.
All right, so we'll start with Article 3, version 3. It is embedded in the agenda, so members of the public can follow along.
Right.
I think we've had successful plan before program to look at it line by line so that we can hopefully come to some conclusions the best we can.
I was gonna ask you about that. I was also gonna ask you about, should we skip directly to the support document for mitigation methodologies and get that out of the way first, or do you want to go through it line by line?
Whatever your preference is. You know, is it better to go through line by line Article 3 to give us a greater understanding of mitigation, or would you rather?
Well, we can. There's some questions that I think Liz had when she went through it, and there are a couple of things. So I think if we do that, we won't get to mitigation for a while, but I do hope we'll do it today. So the question is whether we start with that so that we're sure to do it, or what.
Well,
I'm fine either
let's
way.
just start at the beginning, and
Okay.
we'll plan to get through this and mitigation as
Okay,
goals.
and protection, tree protection is the other biggie that was discussed at the last meeting. There were two biggies from the May 9th meeting. One was tree protection and reports required, and Liz has now provided wording that's been inserted for that, and the other was the mitigation.
All right.
So those were the two unresolved.
Thank you.
The document itself, this version 3, the redlining is there because those are the changes that we agreed to. I think there may have been a few by Glenn, a few cleanup things, but these are basically are changes we've already made. So for instance, on line 43, the trees, 2-inch DBH and 8 feet in height, rather than 4 inches and 12 feet in height, just to give people more options for getting smaller trees or for planting them themselves or for whatever.
I think that's fine. My only comment on line 43 is the use of DBH.
Right.
And I think we need to look throughout the code for the use of DBH because it is no longer part of the definition.
Right.
You know, the period,
Right.
B period, H period.
Yeah, I was going to mention that because what happened was, in one of the earlier discussions, they were both, breast height was there and DBH was there, and the recommendation was to define breast height and take out DBH because they were duplicative. I almost feel like it should go the other way, because DBH is the term that is used. I think the definition should go back to DBH with the breast height as part of that. So I was going to suggest that I redo that.
I would like to see that, because also you'll find out throughout the document and the different articles, the words diameter at
Right.
breast height. So there you've got it in words, but never defined as D period, B period, H period.
And caliper is used, but only for, the caliper is for young trees, is for new trees. The DBH is for established trees. So that there is a different, they are both used at various points. One of the main things I want to talk about is starting at line 46. Liz, I want to also make sure I got this right. You and I talked about it last week. We have talked for a while about how to require the 3 trees. And what's here now is that the first tree would be a high canopy native, the second tree would be a native, and the third would be any permitted species. But I added, in consultation with Liz, a line that all trees are selected from the City of Rehoboth approved residential tree list, which currently looks like this. It's a very nice, handy list. But Liz had been concerned that these three categories were somehow going to be confusing. And so I think what we came up with was that our list in the future would be divided the same way. Column A, column B, column C, as a way of educating people about what's a high canopy native versus a native, and what are these other non-natives that you're allowed to have. Am I correct on that, Liz?
I've all along thought that this is just confusing. One of my objectives is when people submit a tree permit, whatever the planting requirement is, that, like right now, the way it works is I have to go out and I have to determine what they have to plant, and then I have to send them an email saying, I need you to submit a planting plan meeting these following 6 conditions. It would be really great if half the time people could just turn in the planting plan as part, and they wouldn't have to wait for me a week to go out, email them back, study it, then be in a panic to choose their tree species because they need their permit. As long as we're divvying this up and saying, because I thought we did away with high canopy. I thought we just said canopy.
And, yeah.
I don't know.
The law oversight version has a definition of high canopy as 45 feet. 45 feet and I think 25 feet spread or something.
Yeah.
And that actually did not make its way for some reason into the final definitions, and I think that's because we didn't know what height we wanted to describe. But and that to me is one of the real questions: is do we say high canopy or do we just say canopy?
Well, and that was my distinction here. High canopy, you said the Law Oversight Committee has but there is no definition in our Article 1 for
We have to add it.
canopy.
We have to add that.
So I think if you, somehow we need to resolve that.
I mean,
Can't we just have an approved tree list?
yeah, but the way they're dividing it out here, like you have to think that a lot may have 10 Japanese maples on it, and they're like, oh, I'm good, I have 10 trees. Well, on here, that's probably not gonna count for a single one. So,
Well, it would count for the third one, wouldn't it? Or would it be a permitted species or not?
probably not. I mean, there's so many varieties. Some of them are weeping, some of them only grow like 8 to 12 feet.
Okay.
It's like a crepe myrtle.
Right.
Like, there is a Japanese maple that can get large, but it's just the rarity. It's the exception.
Well, that would be up to you, is what's on the permitted list, right?
Yeah.
Remind me, what is the current requirement? It's more convoluted even than this, isn't it? not?
Well, the way I divide the list, you basically can but the way the list is, you have a maximum rather than this is putting it in like minimum. You must
Right.
have one of these. The way the list is now, you can have a max of 1 small species and a max of 1 evergreen.
Okay.
I think that's simpler than this.
So if that brochure is going to have the approved residential tree list, all I read on there is it's a nice list, but it's deciduous and evergreen
Right, because that's
and
the way
other
the
things.
current code is. We're
But
trying
do they
to-
need to be divided into high canopy native and high
would be the idea.
native and?
That would be the idea.
Maybe we just put it down to 2 categories, and you just have to have a minimum of 1 tree from the main category, which is gonna have your oaks, your maples, and stuff like that.
And Liz, could you just restate the reason for the mixture?
The mixture in the current code?
Yes.
The mixture lines 46 to 47, right?
The mixture in the draft or the mixture the way it is now?
The mixture in what you would recommend.
Well, I think the desire is to make sure that we have both native and canopy. So, and a lot of our,
Quality over quantity equation.
yeah, so a lot of our, like, a lot of the bigger trees are gonna be canopy and native at the same time, but there are a few that you would consider canopy trees that wouldn't be native, so like a Zelkova that we have planted on Rehoboth Avenue. very well suited for being a street tree and being near the ocean. I don't know if we want to necessarily encourage them to be planted on private property, but I mean,
but the spirit of all of it is quality over quantity. Yeah.
And to be able to cut, and to be able to assure that we've got canopy trees going forward. I think that was LOC's theme the entire time they were working on it.
Yeah, because when I re-listened to May the 9th, because I was not here that day, it was very focused discussion on quality over quantity.
Right, exactly. And I, I take Liz, well, I do and I don't take Liz's point about the confusion. I would like to think that if we really do want the first one to be a high canopy, and we really do want the second to be native, smaller, medium species native, then why can't we have two lists so that people could select from them? Because if you say it's like, it's the Chinese menu approach, select one from column A, one from column B, how is that confusing?
it's confusing right now. If I'm confused reading it, I know everybody else is going to be confused. I'm not saying it's not worthwhile to have it. If at the end of the day, this is what the commissioners really want and think is necessary, it'll be fine for me to enforce it.
How do we reach the goal and not have it confused? I mean, that's just it. If we have this goal we want to reach, don't we have to have this kind of specificity?
Only if we're serious about the goal.
You're right.
Well, first of all, we don't even need the third may be any permitted species, because if they all have to be from the list, then they'll all be permitted, right? So we can even eliminate those few words right there.
Well, that was just because we were specifying first and second. So
Yeah.
once you do that, you kind of have to say, well, what's third? And so the third is like any. We've talked this one to death.
We have.
I don't know what to do here. Do we want to require a high canopy native tree for one? Do we want to just say that there should be at least one high canopy or? No,
We could have
because we
two
want natives.
You
right?
could have a second category, and it could be the non-natives and the small species, like dogwoods and stuff like that. And you can just say a maximum of one tree from that category out of your three.
How is that less confusing?
Because this has two different requirements, that's one. Max of one from this category.
So say it again. Would you say the first tree had to be a high canopy native?
No, well, I mean, see, you guys, you have it as sequential.
And you're saying?
I'm not sure how the sequential part plays out in my mind right now.
Well, while you're thinking, let me interject a couple things. We have two letters that we received from constituents that were not received in time to embed. Susan, oh goodness gracious.
Right. I have one of them here, but I don't think they commented on this.
Stephanie Smith and also Carolyn Diefendorfer. Does anybody have those printed out?
We have one of them.
I have Carolyn's here.
Which one do you have, Susan?
I have Carolyn's here, but she didn't comment on this
Carolyn,
specific
so
one.
I don't have it printed in front of me. If Susan, you have Carolyn's, if you would just follow along, and
Yeah, no, I will, yeah,
when she,
yeah,
when we get to anything that she mentions, if you don't mind bringing it up.
right.
Does anybody have Stephanie's in front of them? Apparently not. So we will
can get it.
review Stephanie's
get
before the next meeting.
No, I can get it, but I think, yeah, because she had divided hers, so I can
Okay.
easily get it. I don't think there was anything on this one.
Just while you're contemplating that, I also, Glenn, I'm questioning the clarity of the last line there, 48, 49. Larger lots shall be subject to the same proportional sequential tree species requirements. There's no formula there, though. Do we need a formula? Is that clear enough?
How's that implemented?
I mean, I've never, I guess, paid attention to all the drafts, use of the word sequential. I don't really understand that, how it would be applied practically. Because you either have to meet the minimum, you don't have to meet part of the minimum density, you have to meet it all.
Susan,
I see that, this is from law, this is.
Susan, you think if you and Liz work on lines 46 to 49 and bring it back to us and what you think?
Does it mean, though, that, larger lots, their minimum density increases because it's more land mass? So is that what it's trying to say, is larger lots, and you have to, as you add trees, it has to follow the same, I don't know.
That is what.
That's what it sounds like. So, I mean, the easiest formula would be a larger lot. If you've got 100 by 100, then it sounds like you would have to have 2 high canopy native trees and 2 native trees.
Well, it's here on line 32, the formula, 32 through 37 shows the formula, 5,000 square feet or 1 for each 1666 square feet for lots larger, smaller or larger. So there is a proportionality built into it. I guess I hadn't focused on the sequential word of that.
Yeah, I think what the sequential means
so I
is that
haven't either.
if you're large enough that it requires one more, the fourth tree has to be sequentially, you have to go back to what is the first tree supposed to be, right? So
Right.
the fourth tree has to be a high canopy native tree under this construction.
I see.
So it needs a little wordsmithing.
Okay.
Just clarification on the definition of proportionality 32 to 37. It opens and says each single-family resident lot, and then on 46, it just says when applicable on any lot. Does it matter that any lot versus residential lot, or is this is all residential? Is that assumed, or is that, what does that difference mean?
Not in a residential district.
Single-family resident lot, that's very defining, as opposed to when applicable on any lot.
Yeah, because it does line 39 refers to
Right.
mixed use and commercial with residential units.
Yeah.
But there's some lots that are condoed and may have
Multi-family.
multifamily.
Right.
But the requirement would still be the same.
Would it?
I mean, I think we left this in here. I think Liz wanted to leave it in here because even if they don't have the room for 2 trees per dwelling unit, they would then pay into the fund to put those elsewhere. And that there would be equity because all dwelling units would be required to either have or contribute to a tree program, right? Is that the thinking?
Yeah, I mean, that's the way this is verbatim, the way it is now. The only other thing we could do is just go by square feet and just not even just each lot. Because it sometimes too does sometimes become confusing because if I go to a 5,000 square foot lot and it has a garage apartment, then they have to have 4 trees. But it's 5,000 square feet, so really should it have 3?
Well, as I say, this has been in here, so you already go by this code. So now,
Yeah,
so
1
now-
and 2 is exactly how it is now.
All right, so now we're saying, do we want to change that?
Are you finding a problem with interpreting it this way currently?
No, and when I first started, I had to ask Glenn about it because I wasn't sure. We had to research into what a dwelling unit was.
And I'm just curious, what line do we refer to a dwelling unit?
40.
And then I think Glenn was able to pull that definition from somewhere else in our municipal code, maybe the zoning code.
Probably.
I mean, this is a long time ago, and it was basically any dwelling with a eating, sleeping, and cooking facility, so
Well,
condos.
hotel rooms are dwelling units, but in this, at least it says each residence district.
No, we've never used it, the way I remember
Oh, I know.
it being defined as a hotel room, it had to have like eating, sleeping, and cooking facilities. So if it had a kitchen or kitchenette, it would be a dwelling unit.
That is part of the definitions
In the zoning code, I
in the
think.
zoning code, correct?
I mean, when I first started, this is something we addressed like 5 or 6 years ago. I remember
kinda-
it came up and I was like, ooh, I don't know what that means.
That's something we would have to make consistent if we're part of the zoning code.
Right.
Yeah.
That's one of the things we would be looking at, I guess.
Right.
It's not, ever since
So it
I
hasn't been an issue.
consulted Glenn on it, it's not been an issue.
So, Mayor, are you saying that you want me just to work with Liz to get this, the 3 trees thing?
Well, yeah, just so we don't spend a lot of time on it.
I
but-
don't know, I just don't know how to make it any easier. I mean, if our goal is to have a high canopy tree and to have this, and have 2 natives with one being high canopy, I don't know how you do it any differently than this.
Well, we've talked about, we need to, if we're going to include high canopy, we need to define high
Oh, sure,
canopy.
yeah.
Or going to use canopy, we need to define it. Liz also mentioned that maybe there should be a sequence of 2 instead of a sequence of 3. So those are some things I think for you all to talk it through and come to some logical conclusions on that. And then also that's that last sentence, larger lots shall be subject to the same proportional, say, clarification, work with Glenn on that.
All right, so the next one on 54, we had agreed before that line trees will count. I think they count now, right, Liz, or not? No, they don't count now.
No,
okay,
they
but they
didn't.
will count.
They
Okay.
count for nothing.
Okay,
Like,
well,
you
now
don't
they
get
will
any
count.
mitigation requirements from them on either side. So they don't go against you and they don't go for you.
Well, I know I brought this up before, that based on my lot, I've got a huge tree, probably this diameter, whatever that translates to, that was actually probably 100 years ago, 100% on my property. And as it grew, a quarter of it or a third of it is now on city property. So why can't that be counted as a line tree? And before it was not. Carolyn Diefendorf, I think, if I recall, has a comment about there, then how do you define a line tree? Specifically, does it have to involve the trunk, or can it just involve the trunk being offset and the branches overhang the property? So I look up line tree here in Article 1, definitions, and it simply says a line tree is any tree located on a property line. So again, what does located on a
Well,
property
we-
line
It
mean?
used to be any tree that at breast height is astride a property line, and in a previous discussion, we decided we didn't like the word astride, and that we wanted to make it simpler and just say located. So there you go, that's how it got on there. But I guess she raises a point about the, whether or not it means that the trunk is on the line, or whether a branch crossing the line. So is that a clarification we need?
Is
It would be
there,
the trunk, right?
is there a definition for trunk that says from the ground level, a foot high, or something that
So
we could refer to, Liz?
Glenn might be able to speak to this better than I can, but because the courts have gone both ways in settling this, but generally, it used to be the consensus. I won't go for the last 5 years. It used to be the consensus that a shared tree was measured at DBH. So for me, that's right about shoulder height. If any portion of the trunk at DBH height was on another property, it doesn't matter if it's 30-inch tree and 2 inches are on the other property, that's a shared tree. And it becomes important legally because you can't just cut down a shared tree, even if there's no tree code. It's owned by 2 people. So then you start in the discussion, well, what is owned? The majority of the trunk? Or is it where the base of the tree comes from? And the courts used to be pretty even on any piece of the trunk at that height. And I think in the last 5 to 10 years, it's not been that simple.
So it sounds like we need to beef up the definition of line tree to include what Liz just said about the DBH in any portion, right?
Yeah, I think so.
all right,
I think so. Utilizing what Liz just indicated, I'd be comfortable that basically the trunk up to DBH is within the property line boundaries.
Okay, and then 58 was just something we added in a previous discussion about front setbacks, also not applying to lots fronting the boardwalk.
Lines 56 to 58 need some clarification. I think we're just missing one word, where one or more trees are to be planted. It's not reading correctly. Where one or more trees are to be planted to meet density requirements, at least one tree existing or planted shall be in the front setback area. I think that's
Yeah, I think that's
the
probably
omission
right.
there, that's all.
Yeah, okay. And then down on line 70, this has been added a couple places in here by Liz. We talk about applications for building and demolition permits, and she just added house move permits. So we don't have very many of them, but we've had a few. I think, what'd you say, like 5 or so the last few years?
Yeah, probably like the first 2 years I started, we had one, and in the last 2 to 3, we've had about 5. So it is something we've seen a slight uptick in.
Okay. And also at a prior meeting, they'd talked about the requirements being met, not having to be met prior to conveyance or transfer of a lot, but only for a building or permit application. So we took that out at the previous one. And then again, line 78, and this is where caliper comes in because it's talking about planting new trees, replacement trees. So 2 inches and 8 feet rather than the old 3 inches and 12 feet, again, to allow more flexibility. Going up to line 100, this is something that Liz had put a note to add, and I wrote the wording, but it may not be exactly correct. I'll ask Lynn about this. This is where the owner submits to an on-site inspection 12 months after approval, and I thought I have a note somewhere that we'd changed that to 6, but it did not get on here as changing to 6 months. I just can't remember. Maybe we didn't resolve it. But at any rate, Liz reminded me that when trees are planted pursuant to a building permit, inspection is done before the certificate of occupancy is issued. So I just added that.
Yeah, to me, that's kind of an interesting conundrum, that
Yeah.
you're to submit, if you do certain plantings not associated with new construction, you submit for an on-site inspection 12 months later. So we give it time to grow, we're gonna see whether it's healthy and all that stuff. But if it's new construction, how I read this is it's done before the C of O is issued, which is, could be 11 months earlier than the 12-month inspection. So I'm not quite understanding the time frame there.
Could we advance the screen to line 100?
Yeah,
Somebody,
yes, ma'am.
please, thank you.
And Dave, as we go forward, if you raise your hand if you have, okay, so the lines 90, 99 to 102 are on the screen.
Is your intention still to go back and do an inspection 12 months, even if it's new construction? Would you still go back in 12 months and inspect?
So for ones not related to construction, yes. For the construction-related ones, it ends up being longer than 12 months in this era, where most of the custom high-end homes don't take 8 months to build anymore. Maybe when I first started, it was 8 to 12, but now I'd say it's 1 to 1.5 years. But the trees, they typically, it's the one thing we have to ensure they get planted, is you can't have your CO. I still do the follow-up inspection about 2 years later to make sure that the new trees and the existing trees are alive and still there. So they just get an extra inspection, really, the new
But
homes.
what I'm hearing is this doesn't necessarily give a clear picture, because if you do the C of O, you're still inspecting it, you're saying instead of 12 months later, 2 years later.
So say they demolish a house and 14 months later, we go out to, they've built a new one, they're completed. When we go out, the landscaper installed the trees 2 days earlier, because it's like the last thing they do is the grading, the sod, the trees, and landscaping. So the trees have been in the ground for a few days, but it's been over 12 months since I issued the permit. So we do that inspection, say they pass everything, they get their CO, we sign off, they take it to the county, it gets filed away. And I have it triggered 2 years later to come back and double check with the survey that everything is as it was supposed to be.
And so what is the purpose of your inspection before the C of O? More so
To certify,
to certify that they have the required trees before they get the C of O, more so than the health of the tree, which
yes.
is 2 years, up to 2 years
Yeah.
later.
I mean, because sometimes if you just, we went to one the other day, it's super hot. It's the end of July. It's not a great time to judge the health of a tree that just traveled 3 hours on a truck to be installed. But we have a lot, I would say probably 50% have issues with their trees when we go for the final. But then again, probably 75% of the homes actually have issues, period, when we go to the final and require
So
reinspection.
this code provision puts the onus on the property owner to contact your office for inspection. Would it be proper to add on there that they also are required to contact you 2 years after the C of O? Or you're just doing that automatically?
Literally, no one has ever contacted me to schedule this follow-up inspection.
2 years later?
No, any of them. Not the 12-month or any. The only time I get called for that is for the CO.
Okay, well,
And the building inspector does that, right? I mean, that's the trigger for that.
Yes.
Okay, right, not the,
Yeah,
owner-
like
not
they-
the owner, but the building inspector, yeah.
Well, the contractor will call our front desk, and then our admin, whoever answers the phone, say it's Kim, will schedule. It takes a lot of skill on the admin's part too, to be able to know which ones are new construction that require me, so.
Liz, did I could be making this up, but I thought I heard at a previous meeting that will you sometimes do a CO contingent on a planting when the weather is more appropriate?
But now they
I
don't.
don't
I can't,
think so.
I wouldn't say we've never done it. I mean, 6 years, it might have happened once or twice, but I mean, then you would be issuing a temporary CO, and I know that we really don't like doing that.
So what happens if, construction is finished in the winter when the ground is frozen? What do you do in instances like that? Or it's never been an issue or happened?
It's not really, the winter, it's not really that big a deal. Like, we don't get frozen ground here like they may in other areas where you literally can't get a shovel in the ground. I mean, if we have really heavy snow on the ground, that's one thing, but what is it an issue? Maybe a few weeks a year, possibly.
Well, the opposite thing happened to me. I had 2 required trees, and they were installed in the hottest days of the summer that required consistent watering for a long time. And they survived, thank goodness. But I had wondered the same thing, and I think my conclusion at that time is it just puts another level of record keeping to be able to say, we're going to give you a C of O, and then we're going to come back and check you in 4 months or something.
Yeah,
So,
it sounds like it's not an issue. I don't know why I seem to think that had happened more often
Yeah,
than it
I
does.
think the contractors were used to it now. It's just part of the deal that they know that they need to order those trees in advance. Like, they can't be trying to order trees in July, or else they are going to Virginia, Maryland, or wherever to find them.
So my question to you, Liz, do we leave the 12 months in, or should it be 24? I mean, you're saying you do it in 2 years.
No, so there's really like 3 different ones, right? So there's a regular homeowner needs to take out a dying tree at their house. I don't go back to those for at least 12 months, and usually I give them a couple extra months. Then we have the CO inspections, which are done whenever the house is done, right?
I got that.
Final inspection. And then for the new construction, I go back again 2 years after the CO
So,
to officially close out my tree permit and put it upstairs in our files. It lives
we-
downstairs until then.
we need to add that, don't we?
I'm just trying to figure out what is the real objective of this section. Is it to define all the times that you might be inspected, or is it really for the health and safety of the tree? We want to look at it 12 to 24 months later, because you could change it to just say, the property owner shall submit to an on-site inspection of each planted or preserved tree 12 to 24 months after the tree is planted, period. Instead of after the approval of the plan or the permit. Because you're going to do a CO inspection anyways, because they're not going to get a CO unless the trees are there and properly and where they're supposed to be. And that's sort of, that would be built into the zoning code if this it goes into the zoning code, because that talks about COs not being issued until the property is zoning compliant.
I see. Oh, yeah, yeah, okay.
So that one is
Yeah.
sort of takes care of itself.
Yeah,
But I think what this section is trying to address is that, you know, once you have it in the ground, you're not done because we're coming back in 12 to 24 months and taking a look.
Making sure you didn't let it die or pull it out and throw it in the trash or whatever it may be.
Right, so would it be enough just to say the property owner shall submit to an on-site inspection of each planted or preserved tree 12 to 24 months after the tree is planted?
Not after
And
it's
their
planted, 1/3 of them don't plant the trees of the non-new construction, and then I have to then write them up to plant the trees.
Right, but this really just addresses once the tree is finally planted, because then there's different mechanisms to get to the place where it's actually planted. But once it's planted, I thought what this is trying to say is we're coming back to inspect.
For new construction, but for the existing tree permits, I go out, I look, okay, the tree's dying, you have to replace it with one native tree in the front yard, you give me your plan, I sign off, you get your permit, you can do the work, I think the permit's valid for 6 months. And so say 2 months later, you take out the tree. A year after we issue that permit, I go back out and I make sure you planted your one tree in the front yard. If you haven't, you go in the bad pile, and if you have, you go in the good pile, you get completed, you go upstairs. The bad pile I then follow back up on, and sometimes they plant them as soon as I contact them, and sometimes I have to send out a notice of violation.
Right.
But you still need lines 101, 102, right, to remind.
He's saying if it's in the zoning code, we don't because it's taken care of elsewhere, but I think we have to leave it for now, pending on whether we do the zoning code or not, right? So that's one of those things that could change if it goes to the zoning code.
Yeah, I think it would.
Okay.
I just think that there's so much being addressed in this, in lines 99 through 102. There's like 3 different versions of an inspection and a certificate of occupancy, and I didn't know if it could be whittled down because it's only trying to address the 12 to 24 month inspection.
I
But
like the 12 to 24 months to give flexibility. It's just that if this is not going to be part of the zoning code, don't we also need that? So, yeah, okay. Then going down to tree plan required, 25324, Liz had again added house move permit as one of the things that would trigger a tree plan. However, she asked a question about D, that building permit related to any construction where there's land disturbance activity. And this, again, was added very early on. I think it was probably the law oversight edition, I'm not sure. But it's been there forever. And, but Liz has wondered if, you know, is that too vague? Land disturbance activity is defined. Hold on, I'll get to it.
Are you at, where are you again?
Line,
17.
the actually, that's on 118, 119. Hold on, I'll get my definitions up here. Land disturbance activity is defined as any activity that results in movement of earth or a change in the existing soil cover and/or the existing soil topography. Land disturbing activities include but are not limited to clearing, grading, filling, and excavation. So do you still think it's too vague to say land, or are you just thinking that if somebody?
It would literally encompass if somebody wanted to put stepping stones down in their yard, they would have to come and get a building permit, right, because it's coverage. They wanted, say, a trash pad for their 2 garbage cans, which is gonna be, you know, what is that, 6 feet by 3 feet? They would have to have a tree plan? That seems overkill.
What's in the current code?
The current code is vague too, because it has improvements over 500 square feet.
Right, that's right.
And
This is how-
what is an improvement?
That's right. This is what we talked about.
That was
Yeah,
another,
right.
that was another Glenn email.
Yep, and that's what we were trying to get around, because the 500 square foot improvement could be internal and not have anything to do with trees, right?
Yeah.
And, yeah, so that's how it came up to land disturbance, because we didn't want the internal renovations to count, but we wanted anything outside to count.
I
So
mean,
that's,
yeah,
that's
and
how
then
land
at this,
disturbance came
and see, and then we've gone back and forth with dollar figures too,
Yes.
because if somebody is doing like a full strip down of a house, like they're gutting it, that's a lot of land disturbance. It's almost like new construction, if not worse sometimes, in terms of like the equipment, the materials, the contractors.
Is there any, and not to totally confuse things, but would there be a need to address restrictions or guidelines for new construction versus renovation or something of that, two categories? Because we seem to be going, your comments, Liz, keep saying about, well, new construction is this, but if it's just renovating or what have you, is that a different approach to take that would be more clear, or?
I mean, renovating is different, and even an addition is different, or a new pool to an existing house, because they aren't getting a CO technically. So when we hold the CO, we have the ability to make sure the trees are planted. If they're not waiting on a CO,
You've got really no
really
power.
nothing, nothing, the same as any other regular tree permit.
Right.
So in a way, new construction is easier in that sense, in terms of the inspections get done and there's compliance and all that. But any land disturbance is,
I mean, the reason that wording is there is because it is confusing in the current code, and we tried to come up with an alternative
yeah.
that required it for a building permit, but under what conditions, and we settled on land disturbance. So here we are.
Yeah, we did square foot, we did dollar value, and then I'm not sure where land disturbance came from, but at one point, I think the dollar value was like 25,000 or something, and we had discussed that that could be like
That could be
redoing
a
one,
kitchen. Right.
a roof,
Yeah.
siding.
Yeah, but also that could be something that has no
Yeah, a
relevance to trees.
yeah, a kitchen's
Right.
gonna cost more than that, and there's
Right.
very
And
little
bathrooms.
impact to trees if you're
Right.
redoing your kitchen.
Right.
I mean, you have like 2 trucks parking.
So the square footage and the dollar figures didn't work.
Could you use the phrase, in a sense, where there is land disturbance by mechanical activity, or a guy digging a shovel for a pit or something of that nature, I guess, would not be as impactful as you bringing a backhoe in or backing a truck up or something
Yeah.
of that nature?
I'm trying to think how we did the stormwater one. What is that, a disturbance of 1,000 square feet?
Yep, I think so.
Maybe we phrase it in the same way.
Okay. Land disturbance activity of 1,000 square feet or more?
I mean, maybe, I'm just saying,
So it's consistent in the code. if
Yeah.
we-
yeah, I mean, it
I'm
doesn't
gonna
even
look
have
at
to be 1,000, but it'd be
Right.
really easy to trigger that,
Right.
because that is part of their review, and they put it into their computer program and
But
calculate all
again,
that.
but what if somebody is adding a small addition or adding a deck or something that's a little less than 1,000 square feet? Then
Well,
they don't need a tree plan?
I think when they do the 1,000 square foot disturbance, I think they include like the path of travel. So if it's a 600 square foot deck in the back, and then they're gonna have a 20 by 60 square foot of travel, that all gets included.
Okay, so 1,000 was seen as there wouldn't, okay. So on a 5,000 square foot lot, almost anything significant is gonna have at least 1,000 disturbed.
It'd be easy to trigger it that way.
Right, okay.
Because it would be done in Bluebeam, where they measure it all out on the computer.
I mean, that's, we can work with that, you just make that consistent.
Do we need a provision in this code that says unless otherwise determined by the city arborist that a tree plan is not needed?
Well, if we're upping the square footage, I don't think that would be, it's always gonna be needed if it's 1,000 square feet. There is a provision in the current one about tree protection fencing, for 500 square feet of improvements or as determined as necessary. But not as determined as not necessary. Yeah, because remember, the tree plan is just tree protection at the heart of it. If you're not removing any trees, it's just putting up the orange protection fencing, which is a very minor thing.
Okay, so if that seems to be agreeable, we'll just make it match with what's in the stormwater ordinance.
Okay.
Does that work? Okay. There was a note on line 153, actually, that note has been there for several periods of review now, about the administrative fee to offset the cost of reviewing a tree plan review. Is that something we want to leave alone or change?
I would have to know what that includes.
It's for reviewing it's for reviewing a tree plan.
Well, like right now, if you're going to,
Any tree plan.
so if it's new construction and we're charging a tree plan review fee, like if it triggers a tree plan with the tree protection fencing and all that, then we charge them $50.
Okay, and so then, all right, so this
If-
100 is an increase over today's code.
So say it's a lot and it has 0 trees and they have to submit a tree planting plan. I have to give them the requirements, I have to review and approve the plan, and then I have to go out to the final inspection to certify that the trees are installed. That's $50. Now say they're removing trees. We only charge them like and this is where it gets, we may not even do it correctly, but if it's just a regular homeowner removing a tree on their property, they paid $20 to apply and $50 for the permit. If it's a new construction, they paid $20 to apply, $50 for the permit, and then another $50 for like the tree protection plan review.
That's currently,
Yes.
okay.
So the most they would pay would be $120 for new construction. The most anybody else would pay would be $70. So sometimes it's simple. They're just removing a dead tree. They have plenty of others. They don't have any planting requirements. And then sometimes they have a lot of planting requirements and we go back and forth a lot and they need assistance in determining what trees fit. And then I go out in a year and they haven't planted them and then there's more time involved. So it varies. It could be as little as a half an hour's worth of work to as much as, 4 hours, just depending.
So if I'm a homeowner and I have a dead tree on my property, I have to pay $100 to take it down?
No, it says if it's dead or diseased, the fee is
It comes
waived.
back? Okay.
Like currently, the dead tree is exempt from the $50, so it's a free price. You still have to pay the $20, but when I issue it, there's no fee associated.
But this tree plan review is already in the code, right? And it's currently 50. So all this is doing is increasing it to 100, but you're raising the point about the various types of fees. So
Yeah, and I'm not sure if we're even doing it right now. I mean, the way it reads is, let me see, because like I said, if I don't have a planting plan to review, it's usually pretty simple. When you start adding in planting plans, it takes up a lot more time.
And I don't know, this is in the current code. I don't know what we want to do.
Yeah. So as it is right now, a tree plan is required for a tree removal permit. So we would be charging $20 to apply, $100 for the plan review, and then whatever tree removal fees are associated, which I think are inch-related later.
Yeah, they are based on size, I think.
So if we're, I don't know.
I mean, are you saying you want to leave it at 50?
Well, I'm not sure. I'm just saying, like, the way this is different than how we do it now because we don't charge them
But
the
this is in
extra
Isn't this in
50.
the current code?
Yeah, but I'm telling you how we
How you
do
do it
it
in
right
practice.
now. If a
Okay.
homeowner, say the tree isn't dead, say it's dying, it's just on its way out in life. We charge you the 20 and then the 50. Now, if we're really doing this correctly, it would be 20 plus 100, then plus the tree removal fees themselves per inch, which I think are in here somewhere, right?
Somewhere. Well. So what we've added is have we added the fees for based on size?
I think this is okay. It's just as long as the tree removal permit isn't charged 100 and then a planting plan isn't charged 100. Do you know what I mean? Like we're not hitting them twice for the same thing. Or you do tree removal permit is 50, planting plan review is 50, because I'll have people amend their planting plans 2, 3, 4 times and hit me up every single time they're changing species.
This is isn't this a planting plan? Submission of tree plans.
Tree removal permit, demo, house move, building permit,
So it's, okay. So it's a tree
subdivision, site plan.
Okay. But it is a planting plan we're talking about in this section, right?
That's what I'm trying to clarify. When are we charging the $100?
Well, if we have these different tiers of fee schedule, would be better to have a fee schedule in here.
Well,
You know, so that people have a clear picture from beginning to end. It starts up here
Well, I
at
don't think we're clear
$20,
on it.
$100.
I don't think we're clear on what it is, are we?
Tree plan.
What the code states or what we're actually doing may be two different things, is what.
Right, yeah, that's, yeah.
Do you think a
Well,
fee
it's just not
schedule would
clear.
help?
Right.
It's just not clear. And when I started, we never charged them another 50 for a planting plan. And I don't think the code is really that clear on which way it goes. And then how many failed reviews do you get before I charge you? How many amended plans before we charge you? Because every single new construction changes their planting plan, every single one. And when that happens, I have to pull all the files again, review all the tree permits, the planting plans, the building permit, everything has to get relooked at.
And currently,
We don't charge
is
them
we do not charge for that.
$50 for the tree plan review, which is the tree protection, and then 50 for the actual
But
tree
any
permit.
additional work, we're not charging.
Nope.
And does the contractor usually pay that, or is that a bill to the homeowner?
Always goes to the homeowner.
Yeah, but usually it's the contractor dropping off the check, but they fold it into their job.
Contingency fee.
Yeah. No, they account for it. Some of them have things built into their contracts regarding trees. So,
Well, Susan, would you consider creating a fee schedule so that we can clarify all these fees? And then as a separate exercise, tack on there what is an analysis of the fees and whether they're appropriate or not, such as
Certainly do the
including
latter.
labor,
Yeah, okay.
time range, because Liz indicated there's quite a time range there, from half hour to 4 hours to do something. So maybe that would help us.
yeah, I mean, if somebody we need to meet you, we don't understand this, and I mean, you can only account for so much, right? There's always going to be an outlier, but
Okay.
Will there be an addendum in this overall that would have a fee structure? With all the fee
We have
structures
the
in
fees
it?
in the code, and sometimes we don't, right?
Because as a resident, and if I start to look at this, I'll glaze over. And I just want to know, if I have a dead tree that I need to have removed, what's my process, what's it cost?
Well, I've always thought we should have little, instructions. I see these in a lot of municipalities. We don't do it too often, but to have sort of step-by-step instructions, which is not the same as the code, but would make it, would be more
Right.
user-friendly. Yeah.
we do have that checklist. The building and licensing department has a checklist for
Right.
plan submittal.
Okay, all right.
Does it
It
have,
says what
does
you
it have fees attached to it?
I believe it does. I'm trying to find it, but I believe it does.
Does it?
I'm not sure. The tree permit's so simplistic and what you need to submit at first that, I don't know, I haven't even examined it heavily.
Did you say that they change every single time, or was I just imagining? I thought you
Somebody
heard you say
building a
that.
new home, they change their planting plan at least once every single time, yeah. Because what happens is the builder wants to get building, and I say I need 3 trees, X, Y, Z. They submit a plan to me that day. They usually don't even consult with the homeowner because they know it's gonna change. And then usually during the course of construction, the homeowner, we're building beautiful custom homes here, right? That's what's getting constructed. The homeowner is gonna hire either a landscape designer or a landscape company, and they're gonna rework, and the owner is gonna spend a lot of money making the property look beautiful for the most part. And that's not done by the contractor's planting plan of 3 river birches.
I think there's a message there, maybe we're not hearing it. Maybe that would get my attention. I hate the fees, but that would get my attention. If it changes every single time.
So you think it should be a fee for every single time?
That part should certainly be fee-driven. Because we wish they would make, but I guess they have legitimate reasons. They really have legitimate reasons to have to change it. Are you telling me that probably they couldn't have anticipated it? Or just that they didn't anticipate it?
There's two things. So say they, for some reason, already had a landscaper draw up a plan, which would be a rarity. But say it happened. Now we're fast forwarding 16 months. Do you think what the landscaper spec is going to be readily available? I can tell you that answer is no. Maybe some of it, but say if we're specific on a size, you need a 12 to 14 foot tall river birch. They can only find 8 to 10. That's not going to pass. So then they're going to have to go to another species. I mean, it's not uncommon for me to get calls from people that are literally standing at the nursery trying to find a tree.
I don't think we should be nickel and diming
I
our
agree.
homeowners,
But that's
There's a balance in there somewhere.
striking.
Yeah.
Because, yes, I agree, nickel and diming, us processing a $25 payment is probably not worth the time of the front desk, quite frankly. But at the same time, if they're hitting me 3-4 times, where do you draw the line?
Thanks, Mayor.
Okay, so I'll work with her on a fee schedule.
Yeah, fee schedule
Yeah.
and then analysis. Thank you.
And then down in, the only reason I bring this up is because Liz had a question about it on line 174, where we've said if the application for a building or a demolition permit or for petitioning, that was added by us at a previous discussion because subdivision site plan approval in there, so we added petitioning. But Liz, you said something like that you only do tree permits with building permits. So there wouldn't be a tree plan if it's just a demolition or just a petitioning?
For demolition, they have to protect everything unless the tree is already dead or
But
dangerous.
you said for petitioning and subdivision and site plan approval, they don't have to have a,
I don't really know. I mean, I've gone out with the building inspector to ID trees and confirm that surveys are correct. So
But
they
this-
have,
this is actually, now that I think about it, because you had asked the question, that you don't always get them, but this section is about a removal permit. So it's not about any petitioning, it's about how you, it's about the steps to take for a removal permit
yeah, so
specifically.
we don't really issue tree removal permits for demo, partitioning, subdivision. If you're just dividing your lot in half, why would we issue a tree removal permit?
But all I'm saying is, if there aren't any to remove, you wouldn't, but this section is about removal permits, right?
Yeah, that's what it says above it, tree removal permit.
So, it's not, if you don't removing any, then you're not getting a removal permit. That's what I'm saying, am I right? I'm trying to figure out where,
You mean it almost should read, in the case of an application for a building permit, the tree prevents reasonable development.
well, if somebody is is petitioning a lot and they plan to take trees down, then they would need a tree removal permit. But this is,
But it wouldn't be because of the partitioning. It would be because either the trees qualified under one of the other reasons, they were dead, hazardous.
that's true, it says fail to design.
Or
and
they're
improve
building
improvements.
something, a structure.
Supposed to minimize, well, this goes on to say that they want shall not be granted when the applicant has failed to design or locate proposed improvements, demolition, or subsequent to minimize removal of trees.
So I think previously, the city would sometimes allow tree removal permits to be issued during demolition for trees that most likely will be in the footprint of a new building.
But now you don't do that until
No.
there's a building permit.
Because how do you know? We
Yeah,
don't know what
no,
the
that's
site
good.
plan's gonna look like. We have lots that sit for years. Shouldn't
Right.
the trees remain for those years at least? Even
Yeah.
if it is gonna be in the center?
So you think it should just say for a building permit?
Yes.
But what about a site plan approval? Doesn't, I mean, those usually have them.
Well,
I'll say this is the biggest complaint that I've heard from people in the past few years is they're demoing a house, building and licensing will not accept a building permit until after the house is demoed, yet they're going through an expense of saving trees during the demo, which are in turn just being taken down because it's in the footprint of the house.
there shouldn't be an expense with that usually. I mean, they might have to be a little bit more careful, but they always have to put up the tree protection fencing anyways. But they've done it different ways in the past at building and licensing and how they accept the plans. And I think the original way, accepting and reviewing plans before the demo was closed out, led to lawsuits. If I can remember correctly, I can think of one specific one. And so that's why that ended, I believe. And then they tried at least accepting the plans and making sure that they had everything they needed, but not reviewing them until, like, not officially doing them until the demolition was done. And then that led to its own set of problems that people are calling and saying, you've had my permit for 8 months and I've gotten nothing. But that would probably be better questions for the chief building official than me, because I'm just kind of sidelined to that.
I'm not saying it's right or wrong. I'm just saying it's the biggest complaint that I've heard from people.
Because they're on limited time here, right? You can't do it between this date and that date, and it'd be nice to have everything approved and then go and demo and build without that wait. I get it. And it would be easier for me too. I would have one less review to do.
Do you want to say, she's suggesting just saying it for a building permit.
Again, this is from one perspective, and maybe a question to building and licensing to see what their reasoning behind it is. It may be valid, it may be invalid, it may be they don't have the staff to manage that, I don't know. But it seems like there are other aspects. I don't know if Matt has a comment on that, or Evan, if you have heard any experience coming back on those complaints, or it seems like it's maybe a bigger problem than what we're addressing right here.
I'd agree with that.
Yeah.
I think the demo moratorium plays a big role in it too, and that you get this like crush.
Right.
And it's like I can't do anything else during that time frame. Any of my other job duties all get put aside to deal with all the demolition. And I mean, I do 3 demolition inspections. Me, myself, I go there 3 times. Well, they're not necessarily time-consuming inspections, but it's something that has to be called, scheduled, all 3 of them. And I think if you had the new home plans going out at the same time as the demo, you would run into demo problems in terms of time frame.
I think it's a lot more complicated than what we're looking at right now, but I think just a review at some point of all of the processes related to building and tree applications and making sure that the processes are efficient, I think is important.
And actually, that's one of the side benefits of putting this in the zoning code. Because I think all of that would then be looked at. It's not necessarily the reason to do it, but it's one of the side benefits that could result from it.
It just seems to me,
Is it to look at it, not to complicate this to go to 20 years, but is it an aspect of new construction versus, renovation, or how do you define that or whatever? It seems like one size is trying to fit all here, and it doesn't necessarily apply, but.
But for this subsection number 1 on line 174, I don't know how partitioning subdivision or site plan comes into it. It seems to me that if you're asking for a building permit, this deals with, have you made reasonable efforts to protect a tree?
Right.
And that's only going to matter when you have something
Right.
that you want to build and need to remove a tree to be able to build it. Or perhaps in the case of a demolition permit where you have something you want to demolish, but you can't demolish it without getting a tree out of the way to bring equipment in or something along those lines. But for partitioning, when partitioning is simply just drawing a new property line,
Right.
that's not going to require the removal or of a tree. And subdivision's the same thing, drawing property lines. And site plan approval is approving a planned site,
But that would have a building permit.
but you'd have a building permit before you could build.
Yeah, I'm fine with taking that out. I say the partitioning part was added probably because the subdivision and site plan
Right.
were already there to make it complete, but sure. So we'll just leave it at building or demolition permit? Okay.
Yeah, so you're saying remove the partitioning,
Partitioning,
subdivision, or site plan
correct.
approval.
Okay. All right. Moving all the way up on the next page to, we had taken out on line 200, that at the last meeting, I think, just came out altogether. Because I think this says it never happens, right?
Not where it wouldn't meet one of the other categories above.
Okay. And then at the last meeting, there was a little note there to add a provision for removal of trees if minimum density, if the tree is protected and the tree is replaced. And so I guess, Liz, this was your wording. The tree, if the tree is under 8 inches and is replaced with another approved tree meeting minimum tree density.
Okay, yeah, so say they had no trees and they had to plant 3 new trees and they're now, all 3 are about 4 inches and they decide they hate red bud and they want to replace it with the dogwood.
Okay, and
They
it's
can do
under 8
that.
inches. Okay, yeah. Okay,
So the worst that would happen here is that an 8-inch tree gets replaced with a 2-inch tree.
okay,
Somebody changes their mind.
all right. And then you had asked a question about 9B, so lines 210, 211, where, then I think this is in the current code, right? The 10 or more trees? Anyway, you said that you're concerned that someone will just put in an application for 5 and then another 5 in order to get around this requirement for an erosion control plan, but then you were also asking, what is an erosion control plan?
Well, think of it this way. If somebody's removing 10 trees, they're more than likely building a new house or doing like a
Right.
significant addition. I don't get regular permits to remove 10 trees often. I mean,
Right.
maybe like a hedge of Leland cypress or something. I can think of a few times of that. But more than likely, whatever is causing 10 trees to be removed is gonna be, they're gonna be pulled back into the stormwater ordinance with a disturbance of 1,000 square feet or more and have to put up silt fence anyways.
Right, so this, I think this, I don't know if this is in the current code, and I guess I thought it was. So are you saying that the stormwater plan kind of supersedes any need for you to have an erosion control plan? Because we now have
Yeah.
that in the code?
Yeah, I don't think it's necessary. I
Okay.
think this came from maybe law oversight.
Okay, all right, that's fine, because we did not have this. So do we just take it out altogether?
Yeah, I think it's just redundant.
Okay. I'm happy doing that. How do you feel? Okay, that's fine. Okay. And then you got the exempt. I think there is a question here on, from both Carolyn and Stephanie on these.
284.
Yeah, hold on a minute. Well, she first mentions line 197, 198, saying the tree is determined to be dead or diseased, and then 248,
284.
284 rather.
285.
Yeah,
She mentioned that in that section, and that's associated with the
Okay.
fees
Fees,
being
right.
waived, that we should say if the diagnostic testing is required by the city arborist.
So if it is, I think almost if you switch these around, it's supposed to be, it's waived for a diseased tree where you have it tested that the disease was fatal, or a dead tree. So you're not having to get the dead tree tested. If it's dead, right?
Yeah, so you're saying for a diseased tree, it does have to be based on independent verification, or only if you
I would say
require it?
all the time for disease tree, honestly. I mean, I can look at things and say, yes, this has bacterial leaf scorch, but I think it's best to have to get rid of any sense of being like capricious, essentially, to any sense of impropriety. It's just if you're trying to waive all those fees because you're saying your tree is diseased, then we need somebody independently to have it tested, or University of Delaware to come back and say, yes, it looks like it has bacterial leaf scorch, which means that in 3 to 5 years the tree will be dead, and there are no treatments that can reverse this.
What's the cost associated with something like that?
University of Delaware usually does stuff for free, depending. I used to take my stuff to University of Maryland, $100.
And how do you have to take a sample? Is it as simple as putting a leaf in a bag and mailing it off? That's what it is? Okay.
Yep, I would usually, if you're like testing the foliage, is what you would do.
As our expert, though, have you ever encountered where you thought something was diseased and it was not?
Where I thought it was, but then how?
In other words, if you looked at something and thought it was diseased, I don't see the need for us to then go to a third party. That's why I was wondering whether if we went to the third party and then they came back and didn't agree with you.
Almost every single tree probably has some sort of disease if you test it.
Yeah, right, yeah.
Like all the different root diseases, all the different decay diseases. If it has a cavity or a weird lump on the trunk or something, it has a disease. There's some sort of decay or fungus in there. And not all diseases are fatal either. A lot are just maybe aesthetic or slight annoyances or things that can be treated. There are some like bacterial leaf scorch that you can't treat. It just is what it is.
Diseases include or exclude pests? You say you got
Exclude.
adelgids or something,
Exclude. Pests are pretty easy.
something different, okay.
They're and I think that's what you're getting at, is the diseases are a lot more complicated. And there are some that literally can only be verified through testing. You can have indicators. Oh, if you cut the bark and it's a little bit yellow on the outer edge, then it more than likely has this disease. The only way to actually confirm is through testing.
And Liz, I just noticed something, a sort of a disconnect. That's in there about the diagnostic testing under the fees, but earlier, so line 197, where it says the tree is determined by the city to be dead, significantly diseased, severely injured, or in danger of falling, shouldn't the independent verification be there and not in the fee?
I think the independent verification was really more to help them eliminate fees.
Okay.
I mean,
Oh,
because
okay.
think about it this
Okay.
way, if I look at the tree and we can tell that it has something going on, it has a big cavity, it's usually gonna meet like the hazard tree,
For removal.
anyways.
But it would, but,
Which line are you talking about again?
well, I'm just talking about the fact that it's on line 197, it's allowed to be taken out if it's significantly diseased or dead, but in the fees, if they get independent verification, they don't have to pay.
Significantly diseased, severely injured.
And so I'm just wondering if
If they
so
should
it
be
can
the
come out
same.
with just your assessment, but you would want an independent assessment in order not to charge them a fee. Is that what it is?
That's how this reads, because I think 6 is taken from exactly what we have right now.
Correct, yes, it is. And I'm asking if that's where you want the independent verification, or if you just want it on the fee, because this was added in an earlier meeting that you had asked to add the independent verification. But now I'm wondering where it belongs, in the decision to remove or in the fee, and why would it be in
No,
one,
because
not
if
the other?
something is significantly diseased, then it's gonna have other issues that are gonna meet. It's gonna be dying or something like that already.
But can't you, as an arborist, just say it's dead?
Or even that.
Or it's
No, let me
diseased.
ask you, if it's significantly diseased enough for you to approve it to come out, is that not enough to waive the fee? I mean, that's what we're talking about here. We're talking about the fee being waived for dead or
All
diseased
right,
trees.
I'll put it this way. There's been times when I've gone out to places and say they had a 50-inch tree that's dying, and they're like, well, we think it has a disease. And I'm like, well, yeah, it probably does. It probably has a whole host of diseases. But you're not getting, in that case, you get I believe it's a 50% discount on the mitigation. But just because it probably has a disease that you say it probably has a disease, and I agree it probably has multiple diseases, doesn't mean you should just
So
get
do
it.
you approve it or not?
Yeah, if it's dying,
No, but I mean, if it has a disease,
it's going to be dying. If it has
Approved.
if it is significantly diseased,
then
it's
you
going
do
to be
approve
dying.
it. Then you do approve it if that. If
Yeah,
that
so in a way, the word significantly diseased doesn't even technically need to be in there. I think it should be, but
Well,
it's going to have other effects if it's significantly
but
diseased.
that's not, but what I'm saying is, do all of those people then get a waiver on the fee? Because that's what 284 is about.
That's up to you guys.
I mean, why wouldn't you?
I think if she's approving the
yeah,
tree to
why
come
wouldn't you?
out, then
Right.
it should be, the fee should be waived. I don't think we need the
Yeah, I don't think
nonsense
it
of
needs to be
sending it
based
off
on
for
independent.
testing.
I agree. That was added during an earlier meeting, but I don't think it should be there. All right? Okay. Now we come up to one of the biggies. Tree protection. Everything you see in blue there, actually, I think some of the blue part was in an earlier one, but, yes, that's right. Number 5, it's 25327A5. You've seen everything else, that was added by Liz after discussion at the last meeting on a report for a tree protection plan. And the way she has written it is based on heritage trees, which I think we're defining as 24 inches, right? I'm on line 324.
We've gone back and forth. I think I said 20 at one time, but I couldn't remember what we had discussed in the
20 or
in
24,
the
yeah.
meeting, we had discussed all trees requiring a report, and we had discussed just larger trees, and we settled on moving forward with just larger trees. But I don't know if we actually agreed on a size.
Yeah, and heritage trees has been put in at an existing tree of 24 inches DBH.
Which is a big tree.
Yeah. So these and there was a lot of controversy, I remember this from the last meeting on May 9th, about, these plans, and were they expensive, was it an onerous process for the owner? And I think Liz explained in great detail how she used to do them, and they were fairly standard, and they weren't largely expensive. But now, so what we're saying is we're only requiring them for the big trees.
Yeah, so we'll have a bunch of most places won't even need this.
Right.
I'd be surprised if it was more than half of the new construction needed this. I mean, it might be as little as like 20% of them.
So can we live with this then as the reporting requirements for protection? I mean, I think protection I know that, Liz, you had wanted to beef up protection, that you thought that was one of our biggest issues. And
Yeah, I
that's the
mean-
reason this plan, that's the reason this whole section exists.
Yeah, there's only so much we can do with small lots. Like most places, most municipalities, when you read their protection, it's for the whole drip zone at least. Well, that could be like 3 lots here. So, I mean, there's only so much we can do in terms of that width. And, is it really necessarily imperative that you protect a 10-inch oak when you can go and buy a 4-inch oak pretty easily? And I think that's how we settled on the larger trees.
With our lots as small as they are, how does this, there was just a house built next to me. I'm about a foot from the property line. I have an enormous pine tree, which I'm sure was affected, which is what I think this is addressing. Do we look at adjacent properties with this?
Didn't we, so we actually talked about that, Commissioner Gay. I'm not sure if we put it in here. Because remember I mentioned it, I said like neighbor within 10 feet or something like.
Yes.
Yep. If a lot, 324, line 324, number 5.
Yeah.
If the lot contains or is located within 10 feet of one or more heritage trees. I mean, we'll be limited on what we can require them to do for a neighbor's tree. This would include city trees too, because we have a lot of damaged city trees from construction, especially in areas where there's no sidewalk.
So this would be new to the current, current,
So now when I go out, like, so when we get a survey, it only shows the trees on that particular lot. It doesn't show city trees, and sometimes we'll show a neighbor's tree if it's within a foot or two. But I always make note of the condition of the trees and we photograph them prior to demo. That way, if something changes dramatically during the course of construction, we have it recorded. Or if the tree is in bad shape to start, and then somebody wants to come back and say, oh, the construction damaged my tree, well, we have that recorded, it was already in poor condition to start. But we will be limited on what we can actually make them do. We can make them prune the roots cleanly, we can make them put up protection, we can make them more aware of the trees.
Do we actually do that?
No, I'm saying this would,
This would force it.
This is added, yeah.
yeah. But I mean, we can't require them, for example, to fertilize a neighbor's tree. Well, number one, they would only be able to hit half of the drip line, because normally you go in a circle and inject it into the ground. So, you couldn't be trespassing and doing it.
Liz, where in here, I thought you had said that the reports were required to be done by a professional arborist, but I don't see that here.
I thought we did too. If it's not
It
in
says may
there, it
require a
should
copy
be.
of the signed contract for the services, but it doesn't, I'm not reading that it says the report has to be by a certified arborist, or maybe you said it didn't.
No, that would have definitely made it in our, that was definitely in there at one point.
Well, I
If
just
it
took
came
this from
out,
what you sent me, yeah.
Yeah, if it
I
came
took
out,
number
it was-
5 from what you sent me, but maybe,
It must have been accidental if it got removed. Let me see.
well, let me ask this, is the entire protection plan, starting with A, supposed to be done by a professional arborist? In other words, 5 only deals with the extra steps for heritage trees. Is the entire plan, the protection plan, supposed to be done by a
Hold on.
professional arborist? Or is it only the ones for the heritage trees?
Something, because what I sent you isn't quite, here. All reports must be approved by the city. Sorry, I'm pulling up the emails that I sent you with the
Okay.
attachment in it there. And I have like 5 Word documents open. So in what I had sent you, I don't know if it even talks about who does it. It was just the details.
Yeah.
But somewhere along the lines, if that's not in there, it was to begin with.
But for only the heritage tree part, not for tree protection plans
Yeah.
in general? Okay, so
Yeah, it's
only
not
for-
necessary for
Okay,
those.
only, okay. Additional reports, should it just say by a certified arborist are required?
Yeah, I would just say on line 325, all reports must be submitted, prepared and submitted by an ISA certified arborist. We might need to talk about that part too, because there's none around here, but there is another category of consulting arborist. But all reports shall be prepared by a certified arborist and note the tree's size, species, and general health.
Okay. Okay. And, Mayor, on the line above, on 321, we talked about alterations to the tree protection zone must be accomplished, and you wanted to add using best practices instead of, I think we had something more restrictive, like hand digging or something, and there was a lot of discussion about that, so we just put best practices so that it did not obligate them to do hand digging.
Yeah, I made this statement before, and I'll just say it again. These are all great things, and it's laudable because we want to try to protect the trees, especially the trees, big trees that are there. But it's not perfect. because they're still outside of the zone. You can still do a lot of damage and everything. So I just want us to be mindful that this is not a perfect world, it's not a perfect code, but I think we try to do as much protection as we can, you know. You know, I told you before I had done, just because I had bigger trees and I'm the mayor, I wanted to protect my trees and do more than the average person. So I hand dug and very carefully, and I put posts in. I extended the zone wider, but again, then you've got the builder that comes in and does his thing. You know, if you're not there watching them all the time, things happen. You know, all of a sudden you show up on the site and they've just run a ditch witch outside the zone, but 30 feet long to put in this new sewer pipe or something. And you know, a 100-year-old tree that's got a canopy that's 80 feet, you're going to hit roots and everything. So anyhow, I've said my spiel twice on that. Yeah, on line 308, I don't know why I'm just bringing this up, but 308, it says now the signs have to be in English and Spanish. I guess we've got a big Hispanic working population, but I just thought that was interesting that we're targeting some of those. I guess that's valid. On lines 325 and 333, it just mentions heritage trees with a capital on one and a
yes,
lower
right.
cap on the other. No big deal, but
Yeah.
I just made me look at the definition of heritage tree
We did, yeah, we added it. It's been-
and specimen tree. So, the only difference between heritage tree and specimen tree, because they are both equal or exceed 24-inch
Okay, then I think one was-
DBH, is that the heritage tree is of a specific species. And I haven't looked up 253, it's labeled as XX.
I see, yeah, right.
And so I'm curious, is there really a significant difference to require two definitions
No.
versus combining them?
Specimen is what we used to use, and heritage is what you're using now. So do we just omit specimen? Yeah,
Admit one of them, yeah.
Yeah.
Whichever. I don't, if it's just a size-based thing.
yeah.
Okay,
No, I think we just omit specimen, but I'll have to look and make sure it's not cited anywhere.
okay, that's
thanks, good
redundancy. And I'm just going to bring up a historic tree definition, just for this fact. It says, historic tree, as defined in 253-28C, a tree of notable historic interest and value to the city, which is designated by the Parks and Shade Tree Commission.
That-
No, I'm just bringing up that separately to make the point that the Parks and Shade Tree Committee is charged with designating historic trees. So that is something that if this went to the zoning code, we still need that Parks and Shade Tree Commission or some group to be able to do those. I'm just reinforcing what I
Wait, we
mentioned
don't-
earlier.
We don't have historic trees in the draft, do we? I don't think we
Not sure
do.
we do.
It's within the definitions.
No?
I think it's in the current
Current
code.
code, but
And
it's
they've,
not in the new one.
yeah, and we've never designated,
Never designated, that's why we took it out.
eliminated it.
Well, I'll double check. I got it somewhere.
Yeah, yeah,
And you're right, I might have gotten it from the current code,
yeah. I think
in which case,
taken out by heritage.
never mind.
And before we go on to, so does that, are we okay now with the tree protection part?
Yeah, so is everybody fine with lines 295 to 342? Did any of our correspondents mention any
Not
of these
on
sections?
that, I don't think, but I do need to take a step back. But let me just make sure, and we also need to see if a public member has any comment on this. But I don't see anything on here specifically on it. However, I do need to take a step back just to ask Liz a question. One of the people who wrote in was asking about dead and diseased trees, because she says that the category or the description of ones that are exempt from permit requirement are any that have been destroyed or damaged, from extreme weather conditions, insects, disease. She wonders if we should add natural causes such as age as being a reason to remove, so I didn't know whether,
I'm sorry, you're gonna have to give me line numbers on these.
it's not, she's asking a question. Hold on, let me see.
Related,
Three. Okay, so 226, this is under exemptions. For you don't need a tree removal permit if something has been destroyed or damaged beyond saving. And it gives the reasons they would be beyond saving. And she is asking if dead from natural causes such as age belong in this category. In other words, I guess trees that have been destroyed or damaged don't have to get a permit. Trees that are dead or diseased do. Correct?
Yeah, and this is exactly how it is in the current code, and it's
Right.
kind of an issue in the current code because I strongly encourage the tree companies, like say we have a storm and we have a couple of trees fall over in a storm. I strongly encourage them to do like a retro tree permit because how else are we tracking these?
Right.
So if I go out to do an inspection 2 years later, or say they built the new house 10 years ago, so we have a survey showing all the trees, we have a record of all their tree removal permits, and now I'm going out, it's 10 years later, I have the old survey, they want to remove another tree, and I said, well, what happened to these other 3 trees that it shows from 2010? Where'd they go? We have no record. Oh, yeah, they fell over in a storm. You have pictures? No. It's in their own best interest to have it documented.
But I think the issue is you do have to still give permits for ones that are dead, not destroyed in a storm, not like disappeared, overnight. Sorry about that. I just did but not destroyed overnight, but ones that are actually dead, you have to give.
Yes.
Okay, so she's asking, if they're dead from natural causes such as age, should that also be in there? Or is it?
I don't think any of these should be completely exempt because how do we track them? The only time
Okay.
it should be exempt, and I think we have this in the code, is if we're literally declared to be in a state of emergency. If we have a
Right, okay.
hurricane and I've worked through many of those and others, you just can't even keep track of what's happening if you're a tree company. You're just taking down trees left and right, honestly, cleaning them up, putting them on the side of the road.
Well, it does say, or it says, or which constitutes an immediate peril on 227.
Yeah, and the tree companies know if they have something like that happen, just to document it. Most of them have staff, administrative staff or salespeople, and they'll just send me an email or give me a call and, hey, we had this tree that fell on the house at 26 Lake. Is it okay if we go ahead and remove it? And I'll say, yeah, just make sure you document it.
So we should just add a qualification that it has to be documented.
Whatever that is, whether it's a permit or, something.
Okay, why don't I talk to you about this afterwards? I'll just make a note that it's got to be documented, and we'll figure out how.
It's just more about tracking
Okay.
than anything.
Okay, so then going back up to where we are, so if we're okay with the tree protection, then we go to page 9 out of 10. You're doing pretty well here. Line 369 was something that was added at a previous meeting, and Glenn noted that work was needed, so it just wasn't written in code-like language. So I tried to clean that up just by saying, trees must come from a nursery and meet ANSI standards. Trees which are bald and burlap must be planted according to ISA standards. But I don't know that we have described or defined those standards or to what extent we need to. Oh, ANSI standards are in the definitions, American National Standards Institute, okay. ISI is not defined, but is that how you wanted it to read? And is it okay?
I don't even know if we really need it, honestly. I mean, I'm trying to think of times in which trees were like planted embarrassingly bad. I really can't think of any in the last few years.
You had added this previously, that we needed to require that they come from a nursery and that they meet certain standards, and that the ones that were bald and burlap needed to be planted according to standards. We just never did the
I don't
wording.
remember adding that, but I mean, we can have it. It's in the current code to some form.
It is? Okay,
Yeah, some shape or form, it's in there.
okay.
I mean, it's only one line. I don't know why a tree would have to come from a nursery, where else it would come from? Besides a nursery.
So do you want to take it out altogether?
The nursery part is strange. That definitely doesn't need to be in there. If we want to say trees must be planted in accordance with best industry standards or ANSI standards, that would be fine.
Must be planted according to ANSI standards, right? And not mention bald and burlap separately, just say trees must be planted according to ANSI standards?
Yeah, I mean, the ANSI standards cover everything.
Okay.
And we monitor that?
That's what I'm thinking, like, has there been a time in which I went out and I was like, oh my God, this is the worst thing I've ever seen, the trees laying like this or what? Because most of the time when they're in the ground, you can't even tell. I mean, maybe if they still had like a wire basket and it was sticking a foot up out of the ground, in which case I would just say, hey, you paid $600 for this, you might want to call your landscaper.
I mean, I don't understand why stuff is in there if there's no way for us to monitor or enforce it, but it doesn't seem logical to me.
I mean, I'm just thinking if I go out and the tree they planted for, say, a CO is dead, I just tell them I can't pass them. They got to get a live tree in there. Or if it's, half out of the ground or there's a big chunk out of the trunk, maybe, that could be one. I mean, I have told people they have to fix stuff like that, but
Liz, in that same section, line 362, it says, prior to the issuance of the final development approval. Can you help me understand what final development approval is?
no idea.
Where are you?
Line 362, it says, prior to the issuance of final development approval or certificate of occupancy.
Maybe that's covering like the renovations and additions
Yeah.
that don't really get a CO.
Okay.
But is there a
what
stage in the
makes
process
sense.
where the file is closed? Yes, I guess that's what that means?
That's the only thing I can think of.
Is final development approval the right wording, or should it be something else?
I couldn't advise you on that one. I can only guess that that's what that means.
What is it when they close out the file?
I'm sorry, what?
What is it when they close out the file? What do you call that?
Closing out the permit, closing out the application, because like the computer system groups everything relevant, so you might have like 6 permits associated with one project.
Right.
So you can close out the permits individually,
Yeah.
and then once you close out all the permits, you can close out the application.
So should it say prior to the issuance of a certificate of occupancy or the final closeout of a building permit application?
Yeah,
Okay.
I think that's more specific, or at least it makes more sense to me.
Or the final closeout of a building permit application?
Close out of all permits.
Closeout of all
Because there
building
are,
permits. of all-
well, there are multiple permits. They're not all building permits, so,
Aren't they all building permits?
well,
You're getting into technicalities I don't know the answer
I mean,
to
there's-
on that,
there's
probably.
plumbing,
That would be,
electrical, there's,
yeah, but to close out like an addition, you have to have your plumbing and your electrical closed out already. So I think
Okay.
closing out of building permits is fine.
All right, that's fine. Thanks for catching that, Patrick. Okay, folks, it's crunch time on mitigation. I think we're up to that. And I'm going to suggest,
Before we
yeah,
get to that, one of Carolyn's comments was on page 394.
Yeah.
It says, in on-site inspection within 6 months, we changed it to 6 months, but she thought we had up to 12 months to actually plant the tree.
yeah, this is where it was changed, the
Yep.
last meeting to 6, and I don't remember why.
Because I think why it was changed is because this is such a problem to get people to plant their trees if they're not tied to construction.
So you wanted to inspect earlier?
I don't know. I think that actually came from one of the commissioners that said, well, maybe we'll just make it a shorter time frame and it'll bring them around sooner when it's fresher in their minds. I don't know.
But then do we have to change it back where the other part says 12 to 24 months? On line 99, we've said that submits to an on-site inspection 12 to 24 months. This is specifically about mitigation trees.
Yeah, but I think there's something to be said for consistency.
Oh, yeah,
you
no, I
know,
understand that.
So
That's
right
what I'm
now,
asking.
we've got
Yeah, yeah.
6 months, 12
Well, we have
to
the 12 to
24
24
months.
because Glenn wanted us to have the leeway in there rather than
Yeah.
spelling out which is 12 and 24. But, so, the range is not the problem. The question is whether the, the range should be 6 to 24 or whether this should go back to being 12. I don't know.
Twelve is the current standard?
That's what's in the code now.
Liz, is there any problem going back to 12 months, you think?
I don't think it really matters, or at least it doesn't really matter to me either way.
And there's a problem on the next line that honestly I can't say where it came from. I don't know whether it was an incomplete sentence that
Right.
didn't finish putting or what. I don't know what we talked about the property owner must provide, so.
Yeah, I don't know how to read that. For example,
something's
if it
been
is
left out.
determined that the planted tree is dead, the property owner must also provide something?
No, I actually think it's possible that may be, that we were asking that the property owner to provide a care plan for the first couple of years or something. Is that possible, Liz? I'll have to go back
Ring any
and look.
bells
There's
to
something's been
me.
left out, and I don't know what it is right now. I'll have to go back and look at that. But the main thing in this section is the mitigation for which there is a separate document. This is the,
So we're now going to convert from Article
Three.
3 to your support document entitled Mitigation Methodologies, correct?
right, and that mitigation methodologies was a phrase that you, Mayor, came up with at the end of the last meeting to be able to just compare side by side the two versions, the current code, the draft code, but then this third idea that came up at the last meeting for tree mitigation. And of course, I included the code language so we wouldn't have to flip back and forth. So that's what most of this is, going to 3 pages is code language. But the chart really summarizes it on the top there, that what we're really talking about here. And I'll just say, one of the goals since the very beginning of this was to make it to make it easier to administer, to make it easier for homeowners to comply. And by making it easier for them to comply, you also save, you end up with more trees because fewer of them are going to go and try to pay a fee and get out of it. So the idea was, and there were examples, though Liz says there aren't many examples, but the whole reason the current code controversy came up is because there were a few examples of people that had to replace, 100 inches of tree and they couldn't possibly do it on their lot. So they either then paid a big fee or whatever. So, but she says there aren't many of those.
Look, we're delving right into mitigation.
Yes.
For
Yeah.
those that are watching and don't understand it, can you summarize, what do we mean by mitigation? What brings it up on us? Liz or Susan?
Right, currently with
Yeah,
mitigation?
yeah.
If you are removing a tree and it is either 24 inches or larger, or it is a holly, cedar, or dogwood, I think it's 6 inches or larger. I could be getting that wrong, maybe 4.
That was another thing about the.
Then it creates this like total number of inches. So if it's one 24-inch tree, you have 24 inches of mitigation. It can be met offset by what you have existing on your lot. So if you have a bunch of other trees, then you don't have to plant anything. If you have no other trees, then you have to plant 24 inches. And that's,
There are certain conditions in which removing trees, you have to compensate by replanting trees on your property. However, if for certain circumstances don't allow for you to place those trees on your property, there's an alternative called mitigation, in which case you have the alternative to pay for planting them on city property.
That's a fee in lieu. The
So-
mitigation is the planting on the property.
mitigation is just the inches required, whether they're already existing on the property or you have to plant them or some combination of the two.
Okay.
So you're removing a 24-inch tree, you need 24 inches of mitigation. It can be met by existing trees or new trees, or a combination thereof. And then the fee in lieu of mitigation is if you go to Parks and Shade Tree and they charge you the equivalent cost of planting a tree.
That's the next,
Okay.
the fee is the last section.
Okay,
So this is
okay,
just
very good.
this is just
Good.
for
That,
mitigation.
that hopefully helps some that are watching this for the first time.
But then the draft code was to protect all protected trees 8 inches or more, but to not do it based on the caliper size because it, at least theoretically, gets into the ridiculousness of having to plant 100 caliper inches. So, and I think it's possible our tree committee came up with this one, to have one tree for less than 12 inches and then to have, various amounts based on the amount of DBH you were removing, but never more than 4. So no one would ever have to plant more than 4. And I know a lot of people thought that this was a pretty good solution because it got around this ridiculously high number. On the other hand, it means that because that's a different metric than the first one, it was difficult to look at remaining trees counting, and therefore it meant that someone with a heavily treed lot was still having to plant. And so that's where tree for tree came from. Basically, you remove a tree, you replace it with one of the same species so that oaks and maples are getting replaced in kind or from a tree selected from a list. So Liz would have a very targeted list of ones that would be equivalent. And to cover those trees, lots that are heavily treed, there would be no mitigation required, and this is a number that came from Liz, if there are 90 inches of DBH or more remaining on the lot, or the equivalent of about 3 30-inch trees. So the tree for tree is a bit of a hybrid of the others.
And tree for tree does not specify a minimum size of the replacement tree, because it just says 1 for 1.
Well, the size of the tree going in is 2 inches or 8 feet. That's elsewhere in the code.
That's elsewhere.
This
right?
just says that the species is going to, so replace an oak with an oak, but I think we did say at the last meeting a maple would be okay. But you're replacing a canopy with a canopy. You're replacing valuable trees with equally valuable trees. That's what the tree for tree gets at.
I will say all 3 of these are common in tree codes. There's positives and negatives for each one, and none of them are some outlandish thing that we pulled out of a hat. They all exist in other similar forms in other towns and cities.
Well, that's good to know.
Yeah, I mean, like I'm trying to say, like I don't know that one is necessarily favored over the other, honestly.
How did we come up with 90 inches DBH?
I pulled it out of a hat. No. 3 30-inch trees, so our minimum tree density is 3 trees. So we might have to target that per square foot or per lot size, 90 inches per 5,000 square feet. But 3 30-inch trees is a lot on a lot. And I think if somebody has that or some combination thereof, I think we can consider them, if everybody had that and maintained that, would we need a tree code? Probably not, right? So that's kind of where my mind went, but I'd be open to any number.
I'm mindful, there's probably fewer and fewer lots as each year goes by that have forested lots, but there still are some. And I remember back to some people on Oak that, I don't know, took down 50 or 100 trees to build their lot or something. And, for me, a good number of the trees are likely within the footprint of the house. And I hate penalizing those people that build and have to take down a tree versus those that want to take down a tree, so.
Could we use 100 somewhere else?
Maybe, but I mean, does intention really matter at the end of the day? It doesn't matter if they like trees or they don't like trees. If it meets one of the conditions, they have to be treated the same either way.
I will say this, I mean, certainly at the end of the last meeting, I was all in favor of tree for tree. I thought it met the goal of simplicity. It seemed fair, but I will tell you, and this is sort of ironic, because the only reason I know about these codes is because Glenn sent me the name of 6 towns that have tree codes in their zoning code, and when I read them, I saw that at least half of them do make a distinction in the value of the trees, such that instead of having tree for tree, if you have a high value tree, the replacement ratio is anywhere from 2 to 1 to 5 to 1. The point is they make a distinction for valuable trees. And that, you know, so seeing now that other codes do that, it makes me think that tree for tree without that, so in other words, maybe having a combination of the draft revised and the tree for tree, but just having the tree for tree seems to be not protective enough, or not meeting the goal of preservation of tree enough. What do you think, Liz?
Well, I like the thought of ranking
Yeah.
the value of the trees, yeah.
There's also something I saw in some of the research I did. There's a proportionality test that the courts will apply sometimes. It'll say, what's the proportional loss to the community from the trees being removed versus the gain to the property owner? So the courts do try to do some evaluation of that, and the valuing the trees methodology seems to be in line with that test, at least at some of the courts.
Yeah, that's interesting too. Yeah. So, you know, I don't know whether we try to put that in here, well, what it would be, you know, whether it would be, if it's certain species, and that's the way it was in one of these codes. It was like a little chart that had oak and something else where they had to replace them 5 to 1, or whether we just do it based on a heritage tree, and maybe heritage trees 2 to 1, and all the rest want tree for tree. I don't know.
Yeah, I mean, I'm trying to think. I know like the city of Key West, I know some southern cities, they have like 2 or 3 key species they highly value, like a live oak, and I forget what it is in Key West.
Yeah.
And then there was one municipality I worked for, and we actually had an internal, it was called tree valuation. And so if we removed a tree, we would have to go into our chart and say, this size, this species, this is what replacements would be required. And that was our internal requirements, not for the public. And that was years and years ago they had that. And it was complicated, to be honest, even as the staff.
Yeah, and I know we're trying to make it easy. I just, especially after reading those other codes just in the last few days, it has made me wonder, you know, are we doing enough? You know, we want to make it simple, but can we make it simple and also protect these large, and maybe it's just a matter of specifying oaks. I don't know.
Yeah, maybe you just pick 2 or 3 key species and say those have to be replaced on a 2-for-1 ratio.
Is it species or is it circumference of the tree? Or could it
Well, if
be?
it gets to circumference, well, I mean, I guess you could do it either way, right? Over 20 or 24, whatever inch we decided on, could be 2 trees.
I mean, you could have if you will, a skinny oak or a fat crepe myrtle. So,
But we're only talking about protected trees here.
No, still.
So somebody help me. If you have a protected tree, and let's say it is 40 inches, and it's highly valued, if you take it down, I got lost, Commissioner Gay, when you were talking through this. If you take it down, you're not satisfied that you would be putting back the same kind of tree?
And just one, that is what tree for tree is.
I know, but I thought you were saying it just isn't enough for you, and I'm like, I'm not understanding what's not enough.
The number of trees, I think.
Well, just the highly valued, whether the one for one is sufficient enough for the most highly valued trees. In this case, I guess it would be oaks.
So here, take me a step further.
Yeah,
It takes a long time for that tree to become, let's say it's the one for one,
Right.
same tree. It takes a long time for it to be the same or even half the size of the one that was taken out. So if you're suggesting that there has to be 2 of them planted or 3 of them planted, what's the reality of whether or not that can even be done?
Well, think about it. So if you have.
I'm trying to,
All right,
somebody help me.
I think what it is say you have an oak tree. This is how I'm working out in my mind.
Sure.
And it has a 50-foot wide canopy.
Yes,
So you're taking that out.
yes.
Because it's developed some sort of bacterial, let's say bacterial leaf scorch.
Okay.
Fatal disease, you've mentioned it. So you're taking it out. Let's say it's not exempted or whatever, but it's dying. So now we have a 50-foot, and we're going to put in a 2-inch oak with a 4-foot canopy. So the idea is if you put in a couple of those 4-foot canopies, it more quickly makes up for that immediate drop in your canopy coverage. And over time, whichever, it's survival of the fittest, right? So maybe not all 3 of them will do well for the next 40 years.
what do you think is the best way to protect the canopy? Because I understand what you're saying, and so
I think
is that
that's
the
why.
rationale? So that's the rationale for why these other codes have that, is more immediate replacement of the canopy?
I think so, yeah,
I've
that's what
also
makes
heard
sense
you
to me.
say- I'm gonna play devil's advocate here on the other side. I've also heard you say that they're not all going down at once, so that there's variety, and the new one's going in now, so that 20 years from now, when something comes out, the new ones will be. So does that compensate enough so that we can just get away with tree for tree?
I mean, I'm not making up the definition of enough, I think that's the idea behind multiple trees replacing the loss of one.
Yeah.
I mean,
Is immediate.
each tree is not growing enough every year to make up for the loss of a 50-foot canopy tree on the property, right?
Okay.
I mean, it is a natural thing, like when you look at, say, a municipal inventory, you divide your tree sizes into 3 categories, and you want 20% in this size category, 50 in this, and the other 30 in the mature trees, right?
Yeah.
Because you don't want all your mature trees dying at once. You don't want all your trees to be young trees, right? Because then you don't have canopy, so it's always a balance.
Right. I mean, I just go back, again, I was all set tree for tree until I saw some of these other codes, and then, I was also looking at the CDP, and it talks about adopting high standards for replacement. So what are high standards for replacement? What do we really want to do here? I mean, it's like the stakes are higher now.
Well, I guess what bothers me is the term survival of the fittest.
Well,
And I think about, I understand what that means, but it seems, and I'm just thinking off the top of my head, it seems like if you're valuing that tree and you want it to be replaced with something of equal value, you would force it to be the duplicate almost of what was there previously without taking more risk. It seems to me that if you had 3 of them now, what guarantees, which to me the 5,000 square feet comes in, but to me, what guarantees any of the 3 of them would live?
nothing.
So to
A
me,
warranty from the nursery?
just from trying to work it out, it seems like if that's the your resistance to tree for tree, it's,
Question.
no, and I'm glad you asked it, because it's making me think, well, in the long run, it seems more foolproof,
Tree for tree is more full.
tree for tree.
Well, that's important too. And also, I will say this, I did not look at the rest of the zoning code. Oh, sorry, me? Yeah. Yeah, I did not look at the rest of the zoning code on those towns that had that. For all I know, their minimum lot size is 10,000 square feet. I did not look at that, and I probably should have, but anyway.
I think I'm happy with the tree for tree.
Well, I've contemplated, the tree for tree seems very interesting, but I do think there's something appetizing about replacing an oak with an oak and a maple with a maple. And, by the time they're going to be taken down, they're probably pretty darn big trees. So, I'm also mindful that our minimum tree planting specifications went at one time from, weren't they 12-foot high, 3-foot diameter, to now they're 8-foot high. I'd consider tree for specific species, oak, maple, that they have to be a bigger than normal tree. Whether it's 12-foot or I don't know what the mechanics are, planting trees with tree spades, whether we would want to say it needs to be 16 feet, maybe that's ridiculous. But I do think that for certain species that we could possibly specify a much bigger tree than what we are now
I've
proposing.
heard Liz say, and I've heard other arborists say this, because I went through this when I was buying some trees, that the smaller ones catch up and the bigger ones slow down, and so you come out in the same place in a few years.
Yeah, generally.
Well,
between the 2 inch and the
so are
3
you
inch.
looking a few years down the road, or are you looking for instant gratification? I don't think-
I mean, in other words, it really doesn't make a difference. I mean, the 2 inch
that
versus
is
the
that
3
true, you
inch doesn't
think?
really make a
Yeah.
difference. Yeah, I've had to accept, I haven't wanted to accept it, because I wanted a larger tree.
Yeah.
But I've had to accept that based on the
Well,
expertise.
listen, I mean, you can buy
Oh, I know
trees
you
8
can.
inches
Yeah, yeah.
easily from several nurseries.
Right. But you're not really gaining anything, I gather, in the process.
You get the immediate.
Immediate.
Yeah, and people have done that around here. I mean, I remember one time, one woman was like, she bought like she didn't even have to replace the tree, but she did on her own, and she got like a 16-foot tall tree, and she was like, well, I'm 85 years old. I don't have time to wait around for this to grow. And it made me laugh, because I was like, fair enough. I mean,
Okay,
if you
yeah.
want
So, but it's a personal choice, you're saying, it's not necessary. Right.
If you go, just following that a little bit along, tree for tree, and as you've defined it here, it says, the same species as trees removed, or with one tree selected from an approved list provided by the city arborist. Is that a separate list than the approved tree list? Or is that the approved tree list?
My question is, why is there an or? If we're going to do tree for tree, why is or there?
You're saying that no matter what it is, it has to be approved?
well, what if,
No, tree for tree,
what if
oak for oak.
you
Oh, because, okay.
No choice, you're not gonna
took
do an
out
oak.
a dogwood and wanted to put in a red maple? We would consider that a more positive for the canopy. They're both natives, they both support a lot of different creatures, but the red maple, we would consider more desirable because that's a bigger canopy, right? Shade tree. So why wouldn't we allow somebody to replace the dogwood with a red maple?
Okay.
But but I don't think we would allow the reverse.
Well, that's where I was going to go. What happens if it goes the other direction?
I think that's where the list comes in.
So
The discretion,
it would be a separate list then?
I think it would be.
I don't know, I'd have to think
So
about
if
that.
I have an oak and it's coming down and I say I don't want another oak, even though we may say we prize the oaks, I'm going to be given an out.
Well, I thought we talked about a maple potentially, that those
I mean-
would be equivalent last time?
You could do any of the canopy trees, I think.
Okay.
But you'd have to be okay with trading an oak for a tree of lesser value, even if it's still a canopy tree.
Who has to be,
Who makes that determination?
People making the code, right? Whoever's deciding on what these rules are, because every time a single tree comes out, I can't pull out my 5-inch thick tree manual and research that tree and what trees are comparable and the value of this tree versus that tree. That's just not sustainable.
What would you say the top 5 trees in Central Park are? You got, what, oak, maple,
Pine,
pine,
cedar, holly.
cedar, and holly? I mean, I'm all for flexibility. Maybe tree for tree, you list those 5 trees right there in the chart or in the code,
Keep it
rather than
simple.
having to send you to another list somewhere. List those 5 right there. If those are the ones we determine are adequate replacements for other oaks, other maples.
Are there people who specialize in the health of the city tree canopy, who might say, well, you need more hardwood deciduous, you have too many conifers in Rehoboth Beach, or you need more ABCs, and maybe we can't see the forest for the trees. Maybe we should think of an overall health of our tree canopy for stormwater, for cooling and heating, for oxygen respiration. There's a whole bunch of reasons, and it's just beyond me totally. But there has to be some way to evaluate, and they would say, yeah, you lost a 36-inch oak, but for the health of your tree canopy, maybe you should think of planting a medium height tree, or I don't know. And then you could have that, you could say, we need more oaks, we need more deciduous trees. Let's replace that with XYZ. I have a huge Lebanon cedar in the corner of my yard, and I know that's a beautiful, fantastic tree, but it doesn't contribute much to the tree canopy. So if it goes, there may be other ideas. Thank you. I'm just throwing that in to make it a lot more complicated. I'm sorry.
Well, in inventories, like a municipal tree inventory, like I mentioned before, with the size, the age percentages, there is that for species. You don't want a certain amount of one genus, one species, one family. They're not hard and fast rules. And we have a higher percentage of oaks. That would be one that, according to those charts and percentages, we probably wouldn't need to plant more of, right? So,
Yeah, could you do that? Could you say, look, folks, I know you missed your big oak, but think about XYZ.
I think if we do that, it would just be a list, and it would be the same list as the approved residential, where we'd have all the native canopy in one list, and then the other non-native trees and smaller / more ornamental, like a serviceberry, dogwood, Japanese scholar tree, golden rain tree. And if you take out a canopy tree, then you have to replace it with one of the canopy trees in the top part of the list. And if you take out something else, then it has to be replaced with one of the something else list. I think if you start going and valuing every single tree, it'll be impossible.
I think managing them, I think it's a laudable goal, but I don't know that it's realistic for Rehoboth. Again, I kind of like my idea that pick the 5 top trees and put them
Well,
right in
but
there.
she's saying that you might, some of this, because this is over 8 inches or more, that it might be a mid-range tree that's being replaced. So they're not all going to be in those 5 species. Do you,
Well, I'm saying, let's pick the 5 most common and put them in there.
All sizes?
I certainly wouldn't have a crepe myrtle put in there, for instance, to replace an oak, or,
Yeah, but would everybody be okay with a maple replacing an oak? Or a river birch? Or something like that?
I would be comfortable if they grow to a certain height expectation, right? If
Yep,
it's,
and have the columnar forms
Yeah.
not allowed in there, yeah. And that's the metric we're gonna,
the list comes in.
and that's the metric we're gonna go by is height and to an
I have
extent
a redbud
canopy.
tree and a willow oak. I think the willow oak, well, it's shot up in the last year, so that I think will lend itself to the canopy. But the redbud, I'm not sure what height that gets to,
20 feet maybe.
So-
They get a really wide canopy on them.
So compared to my other oaks that are 50 feet high,
Yeah, so if
kind
you,
of dwarfed.
yeah, so if you had to remove the willow oak, it would have to be replaced with like a native canopy tree. And if you had to remove the red bud, you could replace it either with a non-native tree, like a golden rain tree or something like that, or some of the smaller native ornamentals. right? Like a dogwood, serviceberry, redbud.
So any other feelings for these three options for mitigation?
Is there any public
Do
comment?
we have public comment
Yeah.
on this?
Oh, state your name and relationship to the city, please. Oh, let Ann turn on that microphone.
Dave Diefendorfer, city resident. So you guys, again, are doing a great job. This is a very complicated issue. But I'm here again regarding my tree. It's a specific issue that I have. So I have 7 trees right now, including the tree that needs to come down. So, and it's over tragically, it's over 24 inches. Again, my grandfather planted it during World War II, so it should be that tall. So if I go with the draft revised code, I have to plant 3 trees. That's how many trees do I need to have on my 5,000 square foot lot? So I have 7 right now. So I would lose 1. That would be 6. I've had 9 trees on the lot. So I think that is too many. I mean, 1 for 1. I'm in favor of 1 for 1. It helps me, but I mean, how many trees do you have to have on your lot? And I agree with your idea about say I have an oak, I lose an oak. You could have an oak for an oak, if you really think oaks are the best, or you could have like maybe 5 different species, an oak, a maple, that the arborist knows how tall you want to get. So again, so that's what I would be in favor of, and I appreciate if you guys would think about that, because again, my tree is dead. It's not dead yet. Well, it's probably dead, but it was planted so long ago. They have a certain life. But again, how many do I have to plant? So that's what I would like to recommend, that a 1 for 1 tree.
Do you possibly have 90 inches of trees left with the 6?
90 inches, probably not.
So you might,
90 inches.
probably not? Oh, okay, all right. Okay, all right.
Okay?
Thank you, Dave.
Thank you very much.
You know, nothing's easy. You know, we've got, you know, what number should be on somebody's lot, and mitigation is all, to me, very complicated. But, you know, we've got situations like Dave or other people that have even more trees already on their lot. And if they were going to take down some, they have to replace them. And yes, it gets ridiculous where there's no room on your lot, but that's what we have fee and mitigation for. Then again, you also have people that if they take down 2 trees on their lot are liable to only have 1 tree, not be left with 7 or something. So that's where fee and mitigation, in lieu of mitigation, I think comes in. So it's very challenging, but I think part of the goal of our tree code is to not just preserve the big trees, but to grow or at least replace what's taken down the best we can. And to do that, again, that's where if you can't do it on your property, we're giving you an alternative, and that is fee and mitigation.
Which we've not talked about. That is the last thing, the next thing to talk about.
If we do tree for tree, the fee in lieu of mitigation should effectively be eliminated for the most part. I mean, there might be some rare circumstances you wouldn't be able to put a tree back, but I mean, I'm thinking of like a wooded lot might be a problem.
Well,
The
yeah,
lot would meet
except
the
what about
criteria
trees
for 90
taken?
inches, probably. But a wooded lot would then meet the 90-inch, and so they wouldn't have to put one anyway.
Yeah, but the wooded lot, if you're tearing down all those trees on the interior that fit within the footprint of a new house, then you've removed quite a bit. And even if you had to replace tree for tree, that doesn't mean you're going to be able to squeeze them on your property.
No, but you'd have the 90 inches of DBH. So
So he's
you'd
saying
be,
if they're coming down, not if they're remaining.
if you have a wooded lot in your build, I'm thinking of the lot on Columbia that's for sale. They'll probably have 90 inches in the
Remaining?
setbacks. I would hope so,
okay,
in
okay.
between the front and the back setbacks.
Yeah, okay, yeah.
I mean, if not, say all the trees were concentrated in the center of a lot, well, then they'd have the outside of the lot to replant. And I mean, but like I said, those are really rare circumstances. I think a lot of the fee in lieu of mitigation requests or appeals or whatever we want to call it would not happen if we had one for one.
Yeah, unless there's a lot where they're all concentrated, like say there's 10 big ones in the middle, and
Yeah,
so
I
it means
mean,
they would have to plant 10 trees, and maybe they can't, right?
yeah,
So there
But
might be a
most-
place for it.
yeah, but I mean, we would still have it, it just wouldn't be as dramatic.
Right, yeah, I get it. So your funds would go down if you don't have.
So where are we moving on this?
Um,
If it said in the tree for tree column, if it said, blah, 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 replaced with one tree of the same species or one of the following 4 or 5. Is that what we're
Okay.
liking?
I think that would be the cleanest or easiest way to go. I have a question on this, though. Liz, does this, what I think we're trying to address is canopy. So does that, when you talk about same species, does that address the canopy issue?
I
'Cause-
think having only whatever's coming out and 5 additional species to choose from is a problem because we're looking for variety too. That's a healthy urban forest. You have to have a good variety of tree species. But if you make the list right, it could be relatively similar. That's why I said, like, would you be okay with a 75-foot tall oak being replaced with a 40-foot tall river birch? Because that's, if you had a list, that's kind of how it would have to be. You wouldn't be able to just say, okay, any tree that can get 75 feet tall, because there'd be like 3 of them.
Oh, I was thinking about a definitive list of trees.
So
Right.
is 5 not enough variety, you're saying?
For anybody who wants to remove a tree to only be able to select whatever tree they're removing and 5 species to plant?
A protected tree.
Yeah.
Yeah. No, that's nowhere near enough.
Oh, okay.
I think that's
Well,
the
then
whole.
I misunderstood.
Yeah, I think the whole point of when we just restricting it to only native species, which is the way the current code is that there's a lot of tree variety out there, and it'd be nice to have some other trees mixed in. But I mean, our current code has what, 30, 40 tree species you can plant?
But it'll be broken out by a canopy tree, non-canopy tree, and we want a canopy tree to be replaced by a canopy tree. So
That's how when I read that, that's how I envisioned it, would be like oak, maple, river birch, whatever those 30 trees are in the black font on the approved tree list, that would be the canopy tree list. And then all
Well,
the
let's
other
just make
trees
sure
would go in the other.
that's more clear in
That's
the
what I'm-
language.
Yeah, they must select from that list.
Well, that's what I was getting at, my first question. Is this
Yes.
the existing list or is this a separate list? So if it's existing, that's okay. If that
I think it
satisfies the canopy issue.
think it has to be existing. It would get really complicated to have different lists where they have to meet minimum density from this tree list, but then replanting from
Then
this.
if we just change this to one tree selected from the,
Approved list.
well,
The same, should we say same species again, or selected from the list, so that we encourage them to do the same species, or not?
You
or
could
just-
say same species, well, you have to think for space allowance too, right? So it might be hard in some circumstances to take down a red bud and replace with an oak. They might not have the room. So I think same species is fine.
Same species or from a list, from the list.
Yeah, from the canopy section of the list, right?
Okay.
So you can quote unquote upgrade, have a higher canopy species, but you can't go from a canopy tree like an oak to a red bud.
Because I guess where I get a little tripped up is, there are lots that are much bigger than 5,000 square feet.
Yeah.
One of my neighbors is 20,000 square feet. I'm 18,000 square feet-ish.
Yeah, I mean, there's quite a few that are slightly oversized too, 75 by 100.
School
We
view.
see quite a bit.
Yeah.
That can't, the 75, 100, it'll never be able to be subdivided.
Right,
Current, so. But yeah, I think if you extrapolate the 90 inches for a lot size, that should cover that.
Okay.
The way we do the minimum
So
density, same
replace with
thing.
the same species or selected from a canopy tree list.
Mhm. I
Okay,
think that's good.
Going once, going twice.
Well, how many are gonna be on that list?
Isn't the
Well,
list
what
there?
do we have 30 right now.
Okay, so I'm just saying, if it was as few as 5, I would list them there.
Yeah, I don't
If
think
we're
it
gonna
is
have that many,
It's a lot,
then I
yeah.
think we have to direct them to
Yeah.
that list.
Saying why have multiple lists, just have, because it's already going to be divided by canopy.
Yeah, so what if they chose, what if you have 5 species and they chose, they had to meet minimum density some other time and they planted a London plane, which isn't one of the 5, so now they have to, so
Right.
just be confusing.
Yeah, no, I think flexibility of having an extra, because a list can also be altered without altering the code.
I mean, if we want, we could take the list before the commissioners, if
Oh,
we
I
want to
think- I
change
think
it,
we
it doesn't,
should, yeah, I mean,
whatever process we want.
Well, I mean, I think at least this initial one, I guess.
Yeah.
should come before us. Having much to say in that. And I mean, the only other thing on here on page 10 is the fee in lieu, and you'll notice it doesn't have any track change at all. That is because we have always run into a time crunch at these meetings, and we have never gotten to this last page, despite all these discussions. So here we are, and I don't know how much time we want to spend on it now. The key is that the fee in lieu was set at 1,200.
Now, you've abandoned the support document for mitigation.
Well, because we settled.
And now we're
Did we
going
not?
back to Article 3.
Yeah, now we're going back to, I'm
I
sorry.
just want,
Yeah.
people need to be able to
Right,
follow
sorry.
us.
Yeah, so now I'm
Okay.
at line 401, the last section of Article 3, the private property regulator, which is the fee in lieu.
On line 403, Liz, it says where a property is shown clearly not suitable. What are some examples of clearly not suitable for on-site mitigation?
Maybe some of those dual-use commercial with an apartment would be a good one. Or if the number of trees just exceeds what would be normal. You know, maybe it's one of those situations in the current code where they have to plant 7 trees.
Wasn't there just one in Henlopen where it was going to interfere with the driveway or something? Wasn't,
Oh, well.
so was that is that the same sort of issue?
Well, if there wasn't any
Which
other
one you're
room for
talking
one.
about?
Yeah.
Are you talking about on the street, like a city, like a
No,
city tree
you
for
were
the
just saying
driveway?
That they're, after putting in the new driveway, they didn't have room for the tree.
Yeah.
Yeah, but that's a matter of which was
Right.
designed and which came first. That's an aberration. Remember, they had to come in front of the Parks and Shade Tree Commission because their design showed a tree here and their ribbon driveway here, and then the contractor installed the drive first over here,
That was a city tree.
and that it was on
was it?
cities.
Oh,
Yep.
okay.
Yeah,
Mm,
yeah.
mm. Anyway, yeah, is it just, I guess it's just the arborist determination, or that it's not suitable for on-site mitigation? Is that, there's no
Yeah.
room, whatever, right?
That's how it is now, yeah.
Yeah.
Well, to me, like, if we have a minimum density, then that's what they're required to have on their property. And anything above that,
May or may not work.
yeah.
Okay.
If we have a minimum, then that's what that is, it's a minimum.
How do we feel about the flat fee of 1,200 for each? And then that came up because that's the cost of planting and maintaining for 2 years.
Well, where
From Liz.
did that come from? Because
I just said, Liz came up with that number as
We've talked about it, it's not just been me, we've talked about it a lot, and that's
Yeah.
what
Yeah.
Park and Shade, that's what
oh, I
they've
remember
been
the Parks and
charging.
Shade Tree had come up with some kind of fee that,
But it's the planting and care and maintenance for 2 years,
right,
right? For
okay,
2
for each.
Somewhere around there, yeah.
1,200, okay.
Basically half and half, half is the tree itself and getting it in the ground, the other half is taking care of it.
Right, okay.
Right, so that's where
Okay.
that comes from.
With the setbacks that we have for building, is there an example of where, I'm trying to think of an example where somebody wouldn't be able to put a tree in? Is it, because we don't have full lot coverage, do we?
No, but some of the pre-existing non-conforming, like older homes may really have like no front or side yard or no backyard. So sometimes it gets a little bit complicated. Or some of the pre-existing non-conforming might not have any green space at all. I have had one of those recently.
But as the code is revised and we're doing tree for tree, it's going to be less likely that people do the fee
Yeah,
in lieu, correct?
yes. Yeah, I mean, it would be much less likely to happen.
I guess the last thing is this section C, tree protection is a justification for a variance. I can't remember, is that in the current code?
It is.
Is that appropriate to even be in here? I don't know, I mean, I think it's a good idea, I just didn't know if it should be, if it's something that goes in the code or not.
So the reason I haven't had a huge problem with this section is that part of the quick check analysis that the Board of Adjustment is supposed to do is basically a weighing of the benefit to the community versus the harm to the applicant. If so I think that kind of plays into this, that it's okay to say in a code, this is something we're supporting, because it's a policy you've set out, and that's why you have a tree preservation ordinance. It's something that's important to the community. So I think it can be in there. I'd be bothered if it said a variance shall be granted every time.
Okay,
Yeah,
I
yeah.
see, yep, all right, so it's okay to have it in there, okay.
See, I'm gonna push on that, and why are we having it in there? It's never been utilized.
Yeah, I mean,
Never,
it is
to my
not,
knowledge.
and I guess I should say my preference is that it would not be in there, because it does give me a little bit of, but I thought about it, and I don't think that ultimately a court would say this is wrong, but there's some exposure.
And it's never been used, it sounds like.
Right.
So
Yeah,
it's
I mean, if
it's
you're gonna
some
have-
exposure, it's never been used, then maybe it should come out.
Yeah, if you're gonna have incentives, I don't think that would be considered an incentive
Well,
myself.
so then the other question, and I don't want to get into them today because I think we've run out of time, but can you have incentives though in the code or, I mean, how
Yeah,
does
I mean,
that?
so if there are certain things you want to support, for example, open front porches, you can, so long as you do this sort of tree planting or whatever, you can have open front porch that's covered and it doesn't count against you, even the 750 square feet. I don't want to get into the 750 square feet, but like, there are certainly things that you can, you can allow for a little more lot coverage, so long as you,
Okay.
yeah.
I've
So, and
seen,
if this were in the zoning code, those are the kinds of things that could go
see,
in.
I've seen it in tree codes before where they did like a reduction in parking or a reduction in the setbacks.
Right.
So like, say if you can go, our setback is 6 feet on the one side, you can make that 5 feet or 4 feet or whatever, if you're retaining a heritage or specimen, whatever we decide to call it, tree.
So this tree protection has justification for variance. If this were to transfer over to the zoning code, then the appeals are heard by the Board of Adjustment. And then doesn't that justify taking this out? Because they
We're
already
going to
have
take it
their
out in
own-
any case, I
Because
think.
they have their own.
But if it
rules.
becomes part of the zoning code, that's more where the
It's
incentives
more-
would go
Just
in.
more in justification, yeah.
Backing up 1 second, if you will. On the tree for tree, we talk about each protected tree. So if a tree is not protected or falls in the category of unprotected, what is the mitigation? There isn't any? You don't?
Okay, did you give that as an example, Liz? I mean, in other words, if somebody has planted a tree a few years ago and they decide they don't like it and it's only like 4 inches, they can just take it out, right? As long
Yes.
as they meet minimum density requirements.
Yeah, if it's one of their required trees, then they have to replace it.
But if say they put in 4 and they don't like one of them, you said they could take it out. Okay.
Yep. Our minimum is 3. That's what we,
But the minimum for mitigation is 8 inches.
yeah.
That's there for, okay, to allow people to make switches out of smaller, younger trees. Okay?
Yeah, the difference is if it's protected and under 8 inches, you can switch it out with a permit for no reason. If we're falling in there, you have to meet one of the code conditions, dead, dying, hazardous in the footprint of a new structure.
All right.
Okay.
Thank you very much. This has been very productive, I thought. We have marching orders for Glenn and Susan, Liz, and Stan to do some additional homework, and bring it forward. So now the question would be, what is the next date of our next meeting? On the schedule, I have Tuesday, August 16th, special meeting, 9 a.m. for trees. I also have August 30th for trees. Susan, do you?
I do not think the 16th is possible, given all the things that we talked about that are necessary for.
So let's, yeah, so we've got a lot of homework to do. Let's skip the 16th and instead schedule our next special meeting for trees on August 30. Does that sound all right?
I think that's to be determined too.
And we'll play it by ear. I mean, we'll look at, we'll try to pick out some September meetings also. Could be September 13. I would pencil that in as a special meeting, and maybe we can keep this thing going. Are there any further comments? This has been a good meeting. I appreciate that. Dave, thank you for coming. Thank you, Carolyn and Stephanie, for submitting in writing. And if there's no further questions or comments, I'll adjourn this meeting at 12:25 a.m. Thank you very much.
PM.
You're right, I did.
PM.